kung isa lang siya.
Pwede ko
Sa baba na lang. Meron pa ba? Sige. Oh, baba. Hello. Good afternoon. Mahina. Hello. One, two, sound check. 1, 2. Okay. Thank you. Okay.
The Supreme Court podcast is now available on Spotify. Listen to discussions and summaries of significant Supreme Court decisions and other issuances, as well as latest Supreme Court projects.
Have you ever had relatives asking you what's the quickest way to secure an
Is a
annulment?
company policy setting a lower retirement age for women discriminatory?
Can a bank be found negligent for allowing unauthorized
Can you go to jail
withdrawals?
for marital infidelity?
Very honored to have with us Court Administrator Raul B. Villanueva.
Every year, our caseload inventory is decreasing.
Catch the latest episodes on the Supreme Court website and its official accounts on YouTube, Facebook, X, Instagram, and now also on Spotify. New episodes out each may hearing ka. Alam mo paano pumunta sa trial court. Kailangan mo ng court clearance. Alam mo contact number ng korte. Papiyansahan mo anak mo. Alam mo saan ang korte.
Hindi nga eh.
Gusto niyo ba ng civil wedding sa court? May kilala ba kayong judge? May cellphone o laptop ba kayo? Sa website ng Supreme Court, madaling makakahanap ng impormasyon para makatawag o makapunta sa trial courts. I-click ang court locator. Makikita dito ang branch, court type, pangalan ng judge, region o city. Kahit isa lang dito ang meron ka, makikita mo na agad ang court na kailangan mo.
High-tech.
Pindutin ang phone number at makakatawag ka na.
Madali na.
Konektado din ang website sa mobile map para matulungan ka sa direksyon papunta, lakad, drive o commute.
You have reached your destination.
Accessible.
Ang court locator ng SE website ay ginawa para makatulong makamit ng bawat Pilipino ang mabilis at patas na hustisya.
Hello? Sino po sila?
Dito po ba nakatira si Juancho de la Cruz?
Opo, apo ko siya.
Nakakulong po siya dito sa presinto. May kaso siya. Puntahan niyo po at nang mapiyansahan.
Oo. Kumitalaw. Kaninong lola to? Ay, lola niyo. Wala ka din. Kansan mo? Pancho, lola mo yata.
Sir, paano po ba ang proseso ng pagpapiyansa?
Tutulungan po kayo ni Attorney Justicia.
Dito po sa website ng Supreme Court, makikita natin ang mga kailangang gawin para mapiyansahan ang apo mo. Makikita dito sa website ang mga dokumentong kailangang ipunin. Unang kailangan, Certificate of Detention.
Eto na po yun, Lola.
Maghanda din tayo ng litrato ni Juancho. Harap, kanan, kaliwa. 4 na set po. Dapat may pangalan at pirmado niya sa likod. Kailangan din natin ng marka ng mga kamay niya, kaliwa't kanan. Pupunta naman po tayo sa barangay para makahingi ng barangay certificate at sketch ng mapa ng bahay niyo.
Ang susunod ay undertaking. Saan ito makukuha?
Maaari itong makuha sa inyong abogado o sa PAW. Pag meron na, kailangan itong pirmahan ni Juancho, Lola. Susunod po, Lola, pupuntahan natin ang korte na nag-issue ng warrant of arrest.
Paano ko po malalaman kung paano pumunta sa korte?
Ang kagandahan sa website ng SC, meron tayong court locator. Bibigyan tayo ng direksyon paano pumunta sa court. Unang kailangan, certified true copy o official court copy of the information. Pag meron na, ihingi po kayo ng order of payment para sa piyansa. Babayaran mo na rin sa cashier. Ang resibo, huwag kalilimutan. Ayan, kumpleto na. Pwede na tayong bumalik sa korte na nag-issue ng warrant of arrest. Ibibigay natin ang mga dokumentong na kumpleto natin. Kapag wala ng problema, mag-i-issue na ang korte ng order of release.
At ito, ang dadalhin natin sa presinto para mapalaya na ang apo ko.
Okay na to, Lola. Kompleto. Laya na si Juancho.
Salamat at naayos na ang iyong piyansa.
The Supreme Court podcast is now available on Spotify. Listen to discussions and summaries of significant Supreme Court decisions and other issuances, as well as latest Supreme Court projects.
Have you ever had relatives asking you what's the quickest way to secure an
Is a
annulment?
company policy setting a lower retirement age for women
Can a
discriminatory?
bank be found negligent for allowing Can unauthorized you go to jail
withdrawals?
for marital
Very
infidelity?
honored to have with us Court Administrator Raul B. Villanueva.
Every year, our caseload inventory is decreasing.
Catch the latest episodes on the Supreme Court website and its official accounts on YouTube, Facebook, X, Instagram, and now also on Spotify. New episodes out each week. May hearing ka. Alam mo paano pumunta sa trial court. Kailangan mo ng court clearance. Alam mo contact number ng korte. Papiyansahan mo anak mo. Alam mo saan ang korte.
Hindi nga eh.
Gusto niyo ba ng civil wedding sa court? May kilala ba kayong judge? May cellphone o laptop ba kayo? Sa website ng Supreme Court, madaling makakahanap ng impormasyon para makatawag o makapunta sa trial courts. I-click ang court locator. Makikita dito ang branch, court type, pangalan ng judge, region, o city. Kahit isa lang dito ang meron ka, makikita mo na agad ang court na kailangan mo.
High-tech.
Pindutin ang phone number at makakatawag ka na.
Madali na.
Konektado din ang website sa mobile map para matulungan ka sa direksyon papunta, lakad, drive, o commute.
You have reached your destination.
Accessible.
Ang court locator ng SE website ay ginawa para makatulong makamit ng bawat Pilipino ang mabilis at patas na hustisya.
Hello? Sino po sila?
Dito po ba nakatira si Juancho de la Cruz?
Opo, apo ko siya.
Nakakulong po siya dito sa presinto. May kaso siya. Puntahan niyo po at nang mapiyansahan.
Oo, kulay dalaw. Kaninong lola to? Ay, lola niyo. Wala ka din. Kansan mo? Pancho, lola mo yata.
Sir, paano po ba ang proseso ng pagpapiyansa?
Tutulungan po kayo ni Attorney Justicia.
Dito po sa website ng Supreme Court, makikita natin ang mga kailangang gawin para mapiyansahan ang apo mo. Makikita dito sa website ang mga dokumentong kailangang ipunin. Unang kailangan, Certificate of Detention.
Eto na po yon, Lola.
Maghanda din tayo ng litrato ni Juancho. Harap, kanan, kaliwa. 4 na set po. Dapat may pangalan at pirmado niya sa likod. Kailangan din natin ng marka ng mga kamay niya, kaliwat kanan. Pupunta naman po tayo sa barangay para makahingi ng barangay certificate at sketch ng mapa ng bahay niyo.
Ang susunod ay undertaking. Saan ito makukuha?
Maaari itong makuha sa inyong abogado o sa PAW. Pag meron na, kailangan itong pirmahan ni Juancho, Lola. Susunod po, Lola, pupuntahan natin ang korte na nag-issue ng warrant of arrest.
Paano ko po malalaman kung paano pumunta sa korte?
Ang kagandahan sa website ng SC, meron tayong court locator. Bibigyan tayo ng direksyon paano pumunta sa court. Unang kailangan, certified true copy o official court copy of the information. Pag meron na, ihingi po kayo ng order of payment para sa piyansa. Babayaran mo na rin sa cashier. Ang resibo, huwag kalilimutan. Ayan, kumpleto na. Pwede na tayong bumalik sa korte na nag-issue ng warrant of arrest. Ibibigay natin ang mga dokumentong na kumpleto natin. Kapag wala ng problema, mag-i-issue na ang korte ng order of release.
At ito, ang dadalhin natin sa presinto para mapalaya na ang apo ko.
Okay na to, Lola. Kompleto. Laya na si Juancho.
Salamat at naayos na ang iyong piyansa.
The Supreme Court podcast is now available on Spotify. Listen to discussions and summaries of significant Supreme Court decisions and other issuances, as well as latest Supreme Court projects.
Have you ever had relatives asking you what's the quickest way to secure an
Is a
annulment?
company policy setting a lower retirement age for women
Can a
discriminatory?
bank be found negligent for allowing unauthorized
Can you go to
withdrawals?
jail for marital
Very
infidelity?
honored to have with us Court Administrator Raul B. Villanueva.
Every year, our caseload inventory is decreasing.
Catch the latest episodes on the Supreme Court website and its official accounts on YouTube, Facebook, X, Instagram, and now also on Spotify. New episodes out each week.
May hearing ka. Alam mo paano pumunta sa trial court. Kailangan mo ng court clearance. Alam mo contact number ng korte. Papiyansahan mo anak mo. Alam mo saan ang korte.
Hindi nga eh.
Gusto niyo ba ng civil wedding sa court? May kilala ba kayong judge? May cellphone o laptop ba kayo? Sa website ng Supreme Court, madaling makakahanap ng impormasyon para makatawag o makapunta sa trial courts. I-click ang court locator. Makikita dito ang branch, court type, pangalan ng judge, region o city. Kahit isa lang dito ang meron ka, makikita mo na agad ang court na kailangan mo.
High-tech.
Pindutin ang phone number at makakatawag ka na.
Madali na.
Konektado din ang website sa mobile map para matulungan ka sa direksyon papunta, lakad, drive o commute.
You have reached your destination.
Accessible.
Ang court locator ng SE website ay ginawa para makatulong makamit ng bawat Pilipino ang mabilis at patas na hustisya.
Hello? Sino po sila?
Dito po ba nakatira si Juancho de la Cruz?
Opo, apo ko siya.
Nakakulong po siya dito sa presinto. May kaso siya. Puntahan niyo po at nang mapiyansahan.
Oo, kulay dalaw. Kaninong lola to? Ay, lola niyo. Wala ka din. Kansan to? Pancho, lola mo yata.
Sir, paano po ba ang proseso ng pagpapiyansa?
Tutulungan po kayo ni Attorney Justicia.
Dito po sa website ng Supreme Court, makikita natin ang mga kailangang gawin para mapiyansahan ang apo mo. Makikita dito sa website ang mga dokumentong kailangang ipunin. Unang kailangan, Certificate of Detention.
Eto na po yon, Lola.
Maghanda din tayo ng litrato ni Juancho. Harap, kanan, kaliwa. 4 na set po. Dapat may pangalan at pirmado niya sa likod. Kailangan din natin ng marka ng mga kamay niya, kaliwat kanan. Pupunta naman po tayo sa barangay para makahingi ng barangay certificate at sketch ng mapa ng bahay niyo.
Ang susunod ay undertaking. Saan ito makukuha?
The Honorable, the Chief Justice of the Republic of the Philippines, the Senior Associate Justice, and the Associate Justices of the Supreme Court of the Philippines. Hear ye, hear ye, hear ye. All persons having business before the Honorable Supreme Court of the Philippines shall give their attention, for the court is now in session.
Please be seated.
Madam Clerk of Court, please call the cases before us.
Good afternoon, Your Honors. This is a continuation of the oral arguments on the consolidated petitions in GR number 274778, Aquilino Pimentel III et al., petitioners, versus House of Representatives, represented by the Speaker Ferdinand Martin Romualdez et al., respondents. GR number 275405, Bayan Muna Chairperson, Neri Colmenares et al., petitioners, versus Executive Secretary Lucas Bersamin et al., respondents. And GR number 276233, Isambayan Coalition et al., petitioners, versus the House of Representatives, represented by the Speaker Ferdinand Martin Romualdez et al., respondents. Thank you, Your Honor.
Counsel's appearances, please.
With the permission of the court, good afternoon, Your Honors. Respectfully appearing as counsel for petitioners in GR number 274778, Paula Maytan King, Your Honor. Together with me is Michael Ocampo, Your Honor.
Good afternoon, Your Honors. Neri Colmenares, counsel for petitioners Bayan Muna et al. Versus Marcos et al. Your Honors, please.
Good afternoon, Your Honors. Attorney Catherine Jessica I. Distorgi Nigundo, respectfully appearing for petitioners Isambayan and UP Law Class of 1975.
Good afternoon, Your Honors. Attorney Joseph Peter Calleja, respectfully appearing for Seniors Association, Inc., Kidney Foundation of the Philippines, and the San Beda Alabang Human Rights Group. Thank you, Your Honors.
Good afternoon, Your Honors. Attorney Christopher Lau, respectfully appearing as counsel for petitioners in GR number 276233.
Good afternoon, Your Honors. Respectfully appearing for the petitioners in intervention in Aquilino Pimentel et al. Versus House of Representatives et al., GR 274778. Attorney Jose Sani Matula, Your Honor.
Good afternoon, Your Honors, our distinguished amici, and everyone in the session hall. Respectfully re-entering the appearance of the Office of the Solicitor General in all the consolidated cases for all the public respondents except PhilHealth. I'm Solicitor General Menardo Guevara, and with me this afternoon are Assistant Solicitor General George Ortha II, ASG Maria Victoria Sardilio, State Solicitor Rowena Mucha, and a host of other officials and solicitors from the OSG. Also with us this afternoon are DOF Secretary Ralph Recto and DOH Secretary Ted Herbosa, and officials from the Department of Finance, Department of Health, and the Department of Budget and Management. We are ready for the interpellation, Your Honor.
Appearance for PhilHealth.
Good afternoon, Your Honors. Solomon Armusura, Melissa Acorda, Susette Lopez, Yvette Perez, Joan Cristel, Emmanuel Descaliar, all from the Office of the Government Corporate Counsel, respectfully appearing for Respondent PhilHealth, Your Honor. And if I also may mention, Your Honor, Secretaries Amena Pangandaman, Secretaries Bienvenido Laguesma, and Secretary Rex Lon Tigatialian, who are ex officio member of the PhilHealth Board, asked me to relay to the court their apologies for not being able to be here, but they are represented by DBM USEC Janet Abuel, Department of Labor and Employment USEC Warren Miklat, and DSWD Assistant Secretary Irene Dumlao. Thank you, Your Honors.
Thank you. For the record, we acknowledge the presence of the Amici Curay, former Secretary Margarito Tebes, Orville Solon, Sasha Nadine M. Suzara, and Mr. Sani Aplica. Thank you. Justice Alfredo Benjamin Cagiwa will commence his interpellation.
Thank you, Chief. Can I call the Solicitor General, please?
Good afternoon, Your Honor.
Good afternoon. At the outset, I wish to state that all of my questions seek to clarify a number of issues for my benefit, relating to aspects that affect this issue from the perspective of the executive, the budget, the allocation process, the relationship between agencies like PhilHealth and the DOF National Treasury. And in this way, our approach to this issue can be more informed and more robust, so to speak. So please indulge me if in the process, I reboot some of the discussions already had, okay?
Of course, Your Honor.
So that we are all on the same page, can we begin with Section 37 of the UHCA that is being flashed on the screen? And can I confirm from your end that said section provides for 6 sources of funding, namely syntax collections, PAGCOR contributions, PCSO contributions, premium contributions, annual appropriations, and national government subsidies included in the GAA. Agreed?
Agreed, Your Honor.
So let me focus now on the syntaxes as a funding source. There are 4 relevant laws that we are talking about. I will flash them again on the screen. They are Republic Act 9334, Republic Act number 10351, Republic Act 11346, and Republic Act 11467. Do we agree on that?
Yes, Your Honor.
Based on the slide, you can see that Republic Act 9334 was enacted in 2004 10351 in 2012, 11346 in 2019, and 11467 in 2020. Agreed?
Agreed, Your Honor.
Allow me to show you now the different provisions of those different laws and portions that I have highlighted. So let's begin with RA 9334. Under RA 9334, the sin taxes collected are expressly stated to be, and I quote, for the purpose of meeting and sustaining the goal of universal coverage of the National Health Insurance Program, or the NHIP. Agree?
Yes, Your Honor.
Under RA number 10351, the sin taxes collected, again, I quote, shall be allocated for the universal health care under the National Health Insurance Program. Yes?
Yes, Your Honor.
Now, under RA 11346, as amended by RA 11467, the sin taxes collected shall be, and I quote, allocated and used exclusively by PhilHealth for the implementation of the Universal Health Care Act, as shown here in Section 288A, Paragraph A, and Paragraph B, as well as Paragraph C and Paragraph D. My reading of the three laws that we just showed and the highlighted provisions is that a portion of the revenues from excise taxes on alcohol, tobacco, and sugar-sweetened beverages are earmarked exclusively for UHCA. Can we agree on that reading?
Just to be qualified, Your Honor.
How is it qualified?
We have to take a look at Section 37 as well.
All right, I will go there. But for the meantime, Mr. Solicitor General, can we agree that the language of these sin tax laws provide precisely for that? That they shall be used exclusively for UHCA?
Yes, Your Honor, for the implementation of the Universal Healthcare Act.
Yes, okay.
Thank you, Your Honor.
Let me now show you the next slide. This is the 2023 Sin Tax Annual Report. I believe that's prepared by the DOH. And for 2024, on the next slide, the Sin Tax Report. Can we agree, Mr. Solicitor General, that this money generated from the sin tax laws is money collected on a tax?
Yes, Your Honor.
Do we agree that it was levied for a special purpose, namely to fund the Universal Health Care Act?
Yes, Your Honor.
On the screen is the complete text of Article 6, Section 29(3) of the 1987 Constitution. And the plain language here is this: all money collected on any tax levied for a special purpose shall be treated as a special fund and paid out for such purpose only. I don't think you have any objections to that, right?
It is what it is.
That's right. You have, however, taken the position that Article 6, Section 29(3) of the Constitution there on the screen does not apply because of three main reasons. And let me show you what I understand to be your three main reasons. So first will be Section 44, Chapter 5, Book 4 of EO 292, which provides that all income shall accrue to the general fund, and I quote, unless otherwise specifically provided by law. The second ground is Section 10 of the Universal Health Care Act, which provides that, and I quote, and it is highlighted in the screen, for indirect contributors, premium subsidy shall be gradually adjusted and included annually in the GAA, and that, I quote again, the DOH, in coordination with PhilHealth, may request Congress to appropriate supplemental funding to meet targeted milestones. Correct? That's the
Your Honor.
second ground. The third ground will be Section 37 that you just mentioned, which provides that, it's there on the screen, the amount necessary to implement the provisions of this act shall be included in the GAA and shall be appropriated under the DOH and national government subsidy to PhilHealth. Those are the three main arguments I've discerned from your submissions. Am I correct?
Yes, Your Honor.
All right. So let's go through each one. For EO 292, what is important to you is the phrase, and I quote, unless otherwise provided by law. And according to you, that phrase means that the taxing law must specifically say that the collection should go to a special account. Did I understand your argument correctly?
That is correct, Your Honor.
And your example is the Coconut Investment Fund under Republic Act 6260, particularly Section 8. I think that's flashed also in the screen, which says that the fees levied on the account farmer shall go to a special fund. Correct?
Yes, Your Honor.
Okay. At this point, with your indulgence, Solicitor General, can I ask Deputy Treasurer Marino to take the other podium?
Your Honor.
Good afternoon.
Good afternoon.
You want to button your robe?
Sorry.
You have to lose weight, I think. Before anything else, can we clarify again what your position is? You are the Deputy Treasurer of the Bureau of Treasury
Yes, Your Honor.
and the representative of the DOF to the PhilHealth Board,
A secondary alternate. Yes, Your Honor.
a secondary alternate.
Yes, Your Honor.
As Deputy Treasurer of the BTR, you just heard what the Solicitor General explained. You agree with that position, correct?
Yes, Your Honor.
And by virtue of Section 8, Republic Act 6260, how did the BTR or the Bureau of Treasury book the COCO levy funds?
Your Honor, okay. We did not book the COCO levy funds prior to 2012. So these COCO levy funds were not part of the books of the Treasury.
Understood. After 2012, how did you book them?
Okay. So first, Your Honor, when PCGG remitted the funds to the Treasury upon their successful conversion of the San Miguel shares, it was initially booked as a trust liability. And then upon the finality of the Supreme Court decision and the issuance of the EO back in 2015, 179 and 180, if I remember correctly,
That's correct.
it was booked as a special account in the general fund.
So it's a special account in the general fund.
Yes, because of those issuances, Your Honor.
Is it your position that a special account in the general fund, I'll refer to them as SAG-Fs, okay? Is it your position that the SAG-F will be created only if the law specifically says that the collection should go to a special account?
Yes, Your Honor.
That's following Section 8, 6260. Something like that, language to that effect.
Yes, Your Honor.
All right. Do you confirm that there are at least 60 SAG-F accounts in the books of the Bureau of Treasury?
At least 60, yes, Your Honor, as reflected in the table B15 of the BESF submitted along with the other budget documents.
All right.
But, Your Honor, if with your kind indulgence, the Treasury can submit a list that we are monitoring. There's more than what is reflected there.
Fantastic. So if you can submit that list, that will be great.
Yes, but Your Honor, with one caveat, all of the balances there are subject to ongoing reconciliation.
Understood.
With your indulgence. Thank you.
I'm showing now in the slides 10 SAG-Fs. First, for the fertilizer and pesticide program. Second, for the Mines and Geosciences Bureau. Third, the refund of input VAT. Fourth, are those from the BOQ, National Civil Aviation Security Committee, and HLURD. Another for the Seatbelt Use Fund. Then, for the Games and Amusement Board. Another one for the National Building Permit Collections and Remittances. And finally, for the Insurance Commission. In all of these SAG-Fs, they refer to laws that do not have language directing the creation of a special account. Can you confirm that?
I cannot confirm. I need to take a look at the
I can
laws.
assure you.
Okay.
I read those laws. They do not have that language. So going back to the phrase in EO 292, which says, and I quote, unless otherwise specifically provided by law, isn't it more rational to interpret this phrase taking into consideration the entirety and purpose of the law in treating the funds as a special fund, instead of looking for language that specifically directs the creation of a special fund? And I ask this question in light of the 10 SAG-Fs I just identified, which do not have that language. Would you agree with me that that is a more rational way of understanding the phrase unless otherwise provided by law?
Your Honor, if with your kind indulgence, this provision, the Treasury reads this provision together with another succeeding section, Section 45.
That says what?
With your permission,
Sure.
may I read? Section 45, EO of the same EO, same book 6, Chapter 5, Special Fiduciary and Trust Funds. Receipts shall be recorded as income of special fiduciary or trust funds or funds other than the general fund only when authorized by law.
But those are trust funds. We're referring to SAG-Fs.
The income of special fiduciary or trust funds, Your Honor.
So the income goes to a separate account?
There will be a ledger for them, Your Honor, and if it is authorized by law.
Okay. So essentially what you're saying is that additional section you just mentioned now fortifies your argument that there must be a specific language in the law.
Yes, Your Honor.
Even if you have 10 SAG-F accounts that do not have that language.
Your Honor, again, we only establish the SAG-F ledgers whenever there is a provision in the law. Again, we beg your kind indulgence, but I do not have the specific provisions of the law in order to give you a more concrete answer, Your Honor.
That's okay.
My apologies.
That's okay. I'll go now to the second ground of the OSG, to argue that Article 6, Section 29(3) does not apply, and that is Section 10 of the UHCA. The slide shows the second paragraph of Section 10, and it reads as follows. Provided that for indirect contributors, premium subsidy shall be gradually adjusted and included annually in the GAA. Provided further that the fund shall be released to PhilHealth. Provided furthermore that the DOH, in coordination with PhilHealth, may request Congress to appropriate supplemental funding to meet targeted milestones of this Act. Mr. Solicitor General, you refer to the first proviso as meaning that the sin tax collections should go to the general fund and should be appropriated only through the GAA. Do I understand your argument correctly? Yes, Your Honor. In other words, from this first proviso, you conclude that Congress is given the discretion to determine the amounts to be appropriated for PhilHealth, correct?
Yes, Your Honor. I believe that that belongs to the discretionary power of Congress.
This is also your position when you rely on the last paragraph of Section 37, which says, it's there on the screen, the amount necessary to implement the provisions of this act shall be included in the GAA and shall be appropriated under the DOH and national government subsidy to PhilHealth. That, again, is basis for your position, correct?
Yes, Your Honor, because of three key words. Necessary, shall be included in the GAA, and shall be appropriated by Congress.
So, to summarize, based on EO 292, Section 10 and 37 of the UHCA, it is your position that since an appropriation under the GAA is necessary, there is no special fund to speak of, correct?
Special fund
as described in Section 29.3.
Special fund in a general sense, Your Honor, as a policy guideline for Congress to consider when they determine the amount that they will give to PhilHealth by way of subsidy. It's what we call a soft earmark.
So to you, it is still Congress that determines the amount to be appropriated or whether any amount should be appropriated at all, correct?
That's what Section 37 actually says, Your Honor.
And that is where I have problems with your reasoning. Because your interpretation of these provisions totally destroys the mandates of the sin tax laws and the Universal Health Care Act to deliver such funds to PhilHealth for the specific purpose of implementing the universal health care. I'm telling you, that's my problem.
I disagree, Your Honor.
Yes, understood. But the basic principle of statutory construction is to harmonize, correct?
Yes, Your Honor.
To make laws consistent with other laws rather than having one considered repealed in favor of the other.
Exactly, Your Honor.
I'm showing you a slide. That is a quotation from the case of Philippine International Trading Corporation versus Commission on Audit. I underscore that portion. Thus, if diverse statutes relate to the same thing, they ought to be taken into consideration in construing any one of them, as it is an established rule of law that all acts in pari materia are to be taken together as if they were one law.
Yes, Your Honor, in pari materia.
So on the basis of this principle, I'm sharing my thoughts with you. I see sections 10 and 37, which you rely on, as provisions merely to trigger or regulate the release of the sin tax collections directly to PhilHealth. That's my take. I go to you, Mr. Marino. Let's go through the flow of money. After the taxes are levied, the BIR and the BOC remit the money to the National Treasury, correct?
That is correct.
And the National Treasury then puts it in the general fund, not even a SAG-F. That's
that is
correct? According to the 2023 Sin Tax Annual Report, it's there. 178.34 billion was earmarked for PhilHealth. Correct?
It's 83, Your Honor, if I'm reading the slide.
Now, 178.34 for health.
Yes.
Correct?
Yes, Your Honor.
Of that 178.34, the specific allocation for the premium subsidies for indirect contributors of PhilHealth is 83.90 billion. Do you confirm?
Yes, Your Honor.
However, despite being allocated 83.90 billion in sin taxes, the subsidy, which represents the premium payments for indirect contributors, amounts only to 79 billion, according to that. Agree?
Yes, Your Honor.
I call your attention now to the 2024 Sin Tax Annual Report. It was reported that 79 billion of sin taxes collected in 2022 was earmarked for PhilHealth. However, only 40.3 billion subsidy for the NHIP was reflected in the 2024 GAA. This means that around 39 billion of sin tax collections was not given to PhilHealth, correct?
Yes, under the GAA. Yes, Your Honor.
All right. So just to clarify, the figures you just saw in the 2023 Sin Tax Annual Report refer to collections from syntax in 2021, correct?
That is correct, Your Honor.
And the figures in 2024 syntax annual report refer to collections from syntaxes in 2022, correct?
That is correct, Your Honor.
And these syntax annual reports are based on the certifications issued by the BIR and the BOC on the total amounts collected from syntaxes, correct?
That is correct, Your Honor.
I'm showing you in the next 5 slides examples of the BIR and BOC certifications. These were submitted in your submissions. These are the raw data from the BIR or the BOC, as the case may be, certifying their syntax collections for a fiscal year, correct?
Yes, Your Honor.
And it is from these data that the percentage apportionment would then be done, correct?
That is correct.
And the apportionment is computed by the DBM, correct? Following DBM, DOF, DOH, PAGCOR, PCSO, PhilHealth Joint Circular Number 1, Series of 2022.
That is the provision in that circular. Yes, Your Honor.
All right. And this process, this money flow, is actually in accord with the last proviso of Section 288A of the NIRC, as amended by Section 14 of Republic Act 11346, where it says, provided further that the allocation for universal health care shall be based on the collection of the second fiscal year preceding the current fiscal year. Correct?
That's right, Your Honor.
This proviso, correct me if I'm wrong, provides for the appropriate reckoning point from which the allocations for health should be determined, correct?
For the syntax allocation,
Yes, for the syntax.
yes, Your
Yes.
Honor.
And the reckoning point is the actual collections of the second fiscal year preceding the current fiscal year, correct?
Yes, Your Honor.
Now, having computed the earmarked syntax collections for health, the next step is to give the allocation to the relevant agency, such as PhilHealth, correct?
It would have to be appropriated by Congress in the annual GAA, Your Honor.
The reason I went through this flow of money, again, I'm sharing with you my thoughts, is the way I see it, is that the syntax collections are still exclusively earmarked for the specific purpose of funding the UHCA, only that its release is done through the GAA, precisely because the process must be undertaken to determine the actual amount collected and the proper percentage allocation. And that brings me to my conclusion, that the provisions relied upon by the Solicitor General do not really give Congress any discretion to determine the amounts to be appropriated for PhilHealth. So my question to you is this: would you agree with me that this interpretation of mine harmonizes the provisos of sections 10 and 37 of the UHCA with the undisputed fact that the syntax collections are meant to be solely used for implementing the UHCA?
Your Honor, I am not in a position to agree or disagree with the legal interpretation, but if I may share the historical experience when it comes to these earmarkings or appropriations.
Now, wait, hold on. Let me just continue with my questions. All right. I refer you to the second proviso of Section 10. There's a proviso there that says, provided further that the funds shall be released to PhilHealth. The funds collected shall be released to PhilHealth. In other words, if the syntax laws already determine the source and use of funds to implement the Universal Health Care Act, even if the funds pass through the GAA, their character as earmarked for a special purpose remains intact. Would you agree with my interpretation?
As a declaration of policy and priority, Your Honor, yes, if we interpret earmarks in such a manner.
All right, thank you. And doesn't my interpretation, again, I'm sure I'm very candid, I'm sharing my thoughts. Would you agree that my interpretation as to the allocation of the funds through the GAA, this aligns more with the constitutional requirement under Article 6, Section 29(3), that money collected on any tax levied for a special purpose shall be treated as a special fund and paid out only for such purpose. Don't you agree that my interpretation aligns more with that provision of the Constitution instead of undermining it?
Your Honor, again, my view is influenced by that provision in the EO 292 regarding the
Which is secondary
meaning.
to a constitutional edict, correct?
We understand, Your Honor.
Okay. Given all that we've discussed so far, can I go back to Article 6, Section 29(3)? We're talking plain language here. Can we all agree, Mr. Solicitor General, Mr. Marino, that the plain language of this provision is that if money is raised from levy of taxes for a specific purpose, then it shall be treated as a special fund. That is a directive of the Constitution. Can we agree at least on the plain meaning of that provision?
I guess we can, Your Honor.
Okay. Okay, before I leave this topic, can I, Mr. Marino, are you familiar with Treasury Circular number 4-2024? Defining a SAG-F.
2004, Your Honor.
2024, defining a SAG-F.
I am. Yes, Your Honor. Yes.
I'm flashing to you section 3.9. It defines a SAG-F. This is a Treasury Circular, okay? It defines a SAG-F as a fund whereby proceeds of specific revenue measures and grants earmarked by law for specific priority projects are recorded. This is the same definition as in the Unified Accounts Code Structure Manual. Are you familiar with that definition?
Yes, it is also the definition of the DBM in their glossary of terms, Your Honor.
And therefore, reading from that, if a specific revenue measure is earmarked, the word is earmarked, for a specific project, I refer to the Universal Health Care Act, it should be recorded as a SAG-F by definition, correct?
Again,
By definition.
Again, Your Honor, this circular has to be reconciled with the section 45 of the Admin Code, Your Honor.
Understood. But by definition of your definition, I'm correct, am I not? It should be recorded as a SAG-F.
Your Honor, if I may, again, without section 45, then yes, I may agree. But we have to reckon with the provision of the Admin Code as well.
All right.
Your Honor.
I will digress. SAG-F is a special account in the general fund, correct?
That is correct, Your Honor.
And in the last oral arguments, you admitted that special funds derived from sin taxes are commingled with all other funds of the government in the general fund.
Yes, Your Honor.
It's not even in a SAG-F, correct?
It is not in a SAG-F, Your Honor.
And therefore, in that scenario, the funds derived from sin taxes can be used for purposes other than that specified in the law because they are commingled in the general fund, correct?
The cash resources, Your Honor, are of course fungible.
Yes, pero pag inubos mo lahat, magagamit mo yan, di ba?
Pag inubos po lahat, Your Honor, we are obliged to raise resources in order to make sure that
correct. But
the funds for the
SAG-F, but the funds that originally came from the sin tax laws are gone.
The specific cash, Your Honor,
they're
very
gone.
likely.
Yes.
Very likely. But again, funds are fungible, Your Honor.
Understood. Understood. Let me ask you as a Deputy treasurer, don't you think there's something wrong about a special fund created by law for a special purpose, that it can be used for purposes other than what it's used for, what it's supposed to be used for?
Your Honor, if we are to talk about the earmarking or SAG-Fs in general, then our interpretation is that these are accounting entries. These are accounting obligations.
That
And-
refer to actual monies that entered your pocket.
Yes, but the relevant comparison, if I may, Your Honor, the analogy that I will use is that of a bank account. So when we deposit our funds in a bank account, definitely there is cash going into that bank account. But we do not expect the bank to keep the cash in a vault or under the ground. We expect them to deploy the resources, but when we require any withdrawal, then we will be expecting the return or the balance that they have
All right.
indicated.
Understood.
So that is our interpretation.
But aside from the
Honor.
general fund, you have other funds, right? Trust funds.
Yes, Your Honor.
They're not commingled.
For the trust fund, they are carved out, Your Honor.
Completely.
Yes.
They cannot be touched.
They cannot be touched, Your Honor.
Correct?
Yes.
So why can't we treat funds derived from taxes for a special purpose in the same manner? You call it a SAG-F, but it's still commingled. Why can't we treat it that way?
Because, Your Honor, by its name, it is a special account within the general fund. Presidential Decree 1234, consolidated all of these special accounts outside the Treasury and then consolidated them as special accounts to be held by Treasury. So the very law that introduced the concept of a SAG-F
Alright.
already
I'm not
implied
questioning the history. I'm familiar with PD 1234.
that. Yes, Your Honor.
My question is, in your opinion, would you agree that in order to preserve the special funds that are declared by law to be used only for a specific purpose, wouldn't it be better to set them aside from the general fund? Or even if you were to call them as a special account in the general fund, that we put guardrails so that they will not be used for a purpose other than what they were levied for? You see, the question is, they were levied for a specific purpose, and now it's being used for something else. Don't you think, since your Treasury, and maybe that will be part of the decision of the court, if we can put some guardrails there, because it doesn't make sense to me personally that a law specifically earmarks a fund for a specific purpose, and it goes into this well where it can disappear, which is not addressed by an answer that says, oh, we can always borrow funds.
Okay.
Yes.
May I, Your Honor?
Yes, please.
Okay, with your permission. So, Your Honor, one of the regular positions adopted by the economic managers when it comes to their comments for appropriations bill or any basically earmarking of funds is to strongly discourage such practice. Because number one,
Yes.
it reduces the flexibility.
I understand.
And of course, from the point of view of the Treasury, to carve out those cash resources, to allow it to make it impossible for Treasury to use simply means that we need to borrow in order to pay for the other
Yes.
obligations. That would be, in this environment, more fiscally ruinous to the health of the
But
country.
that is the perception of the economic managers. I'm talking about a carve-out by law. Are the economic managers free from following this law?
The economic managers are obliged to follow the dictates
Exactly.
of the law, Your Honor.
And the law says this. Therefore, moving forward, should the court decide that these are special funds and they cannot be touched and they cannot be used for any purpose other than that, will the Bureau of Treasury comply?
Your Honor, if the court decrees it so, then we have no choice but to comply. But if I must highlight the implication, in the table B15 of the earmark revenues for SAG-F, DBM already highlighted a balance of 600 billion pesos or so. internally, we have more when it comes to earmarks, SAG-F earmarks for that matter. If we are obliged or commanded to make sure that there is cash backing those earmarks at all times, then we will have to drastically bloat the borrowing program far above the levels that the economic managers or our international partners would deem fiscally credible, fiscally healthy.
Okay,
So,
so-
that, Your Honor.
Can I ask that you submit a memorandum on that issue? Because
Yes,
that's
Your Honor.
important to me.
Yes, Your
And
Honor.
what I want to see is whether or not doing so, what are the economic impacts of doing so?
Yes, Your
I
Honor.
think that is for a better informed judgment on our part.
Yes, Your Honor.
All right. Thank you, Mr. Marino. You can take your seat. I'd like now to talk about Section 11, the most important section that has been discussed all throughout. And can we have that flashed on the screen? I'd like to talk about reserve funds. Okay. My first question, Mr. Solicitor General, refers to the first proviso. It says, provided that the total amount of reserves shall not exceed the ceiling equivalent to the amount actuarially estimated for 2 years projected program expenditures. That is the language, correct?
Yes, Your Honor.
So it calls for an actuarial estimate. Am I correct that PhilHealth has an office of the actuary? There is, correct?
Yes, Your Honor.
All right.
According to PhilHealth.
And I'm correct that it is headed by Ms. Yolanda De Leon? The office of the actuary. Nerissa De Leon is on top of her. The office of the actuary is Yolanda De Leon. Is she here? No, she's not. Yeah, can you come over? Yes, pero hindi siya yung head. Siya yung head ng actuary.
Last time she was not.
No, she's Nerissa San Jose. Yeah. I understand the policy.
Good afternoon, Your Honors.
Afternoon.
Good afternoon.
You are? Can you state your name?
Yes, Your Honors. I am Nerissa Santiago. I am the Acting Senior Vice President of the Actuarial Services and Risk Management Sector, for which the Office of the Actuary is under, Your Honors.
It's under you?
Yes, Your Honors.
According to the CV of Ms. De Leon, since she's not here, which I will confirm with you, she has been with PhilHealth since 1999. Correct?
That's correct, Your Honor.
And per her CV, she has a bachelor's degree in mathematics, a Master of Science in Applied Mathematics, major in Actuarial Science in 2007. Yes?
That's correct, Your Honor.
I looked at the scope based on her CV. She listed down her scope of duties. I think you will be familiar with them. They include, among others, if you can flash that on the screen. Number one, ensuring that appropriate protocols in statistical and actuarial analyses are employed by the department. Second, evaluating the reasonableness of projections, estimates regarding membership coverage, collections and benefit claim costs. Reviewing data, reporting findings, results derived by the department, and making the appropriate recommendations. Number four, if you can move the screen. Helping determine company policy and explaining complex technical matters to company executives, 5, within the guidelines set, direct the preparation, review, consolidation, and recommendation. These are just some of her duties. I'm asking you now as her boss. You are her boss, right?
That's correct, Your Honor.
That these responsibilities are accurately described.
That's correct, Your Honor.
Okay, just for the record, I'm showing on the screen the organizational chart of PhilHealth. That is already you are Nerissa Santiago.
That's correct, Your Honor.
Below you would be the Office of the Actuary on the lower left bottom portion.
That's correct, Your Honor.
All right. In this Office of the Actuary, you have a number of officers, correct?
That's correct, Your Honor.
They are called Senior Associate Actuary, Associate Actuary, Assistant Actuary, and Financial Analyst, correct?
That's correct, Your Honor.
Okay. Just for the benefit of all, I'm flashing on the screen the qualification standards of these officers, and I'd like to go through each one. Senior Associate Actuary must have a master's degree, preferably in the field of mathematics, actuarial science, statistics, or finance. For an Associate Actuary, bachelor's degree in the field of mathematics, actuarial science, statistics, or finance. For an Assistant Actuary or a Financial Analyst, bachelor's degree in actuarial science, statistics, or applied mathematics, or other related fields. Did I say that correctly?
That's correct, Your Honor.
Am I correct in saying that the actuarial estimates that appear in the financial statements of PhilHealth are prepared by these qualified individuals?
That's correct, Your Honor.
Now, going back to the text of Section 11, Miss
Nerissa Santiago.
Miss Nerissa, you are familiar with Section 11.
Yes, Your Honor.
How long have you been in PhilHealth?
For almost 17 years, Your Honor.
All right. So you're familiar with how Section 11 operates?
Yes.
All right. When Section 11 provides that the ceiling of the reserve funds can only be determined by an actuarial estimate, kayo yun, di ba?
Yes po, that's correct, Your Honor.
Okay. Let me refer you to page 54 to 55 of the 2023 audited financial statements of PhilHealth with the heading Reserve Funds. In item 26.1 of the notes to the FS, it says that the amount actuarially estimated for 2 years projected program expenditures is 560.55 billion pesos. Correct?
That's correct, Your Honor.
In broad terms, in broad strokes, Nerissa,
Yes, Your Honor.
can you tell us how you came out with this estimate?
The estimate for the 560 billion is our estimate for the expenditures that will be spent, since this is as of December 31, 2023, that would be the expenditures for 2024 and 2025. So that will include the estimation for the benefit expense payouts and the operating expenditures.
Did you also consider the number of people who become qualified? What are the factors that you looked into?
Okay. For the benefit expense estimation, we rely on the benefit plan of the corporation for which this is being submitted to DPM as part of the requirement for the next 3 years. No? So the benefit plan will include the different benefit enhancements that will be done for the next 3 years. Okay. So the benefit plan will include if the benefit enhancement, for example, one of the benefit enhancements that was included in that estimate is the primary care benefit. For the primary care benefit, there is a target of the corporation for which the corporation will be able to cover in terms of primary care services the number of the population, the percentage of the population that will be covered. So.
And this is the process you follow every year?
Yes, that's correct, Mr. Chair. Your Honors.
And when DOF implemented special provision number 1D, it did not use the actuarial estimate, did it?
Yes.
It disregarded your amount.
It effectively because of the DOF circular, I think this is as part of the, in compliance to the DOF circular that had been issued by the DOF.
Yes.
Your Honors.
I'm showing to you DOF's table of PhilHealth's 2-year actual expenditures in Philippine billions, which is page 8 of Annex A to the compliance of the OSG. Have you seen this table?
Yes, Your Honor.
Do you confirm that this table represents DOF's computation of the ceiling mentioned in Section 11?
Since the DOF is the one who issued the circular, then the calculation made by the DOF, I would presume, would be
Can I
in
ask the
accordance
Solicitor
with
General, can we agree that this is the DOF's computation of 2 years projected program expenditures?
No, Your Honor.
This is not?
No.
What is
the
this?
computation by the Department of Finance was based on disbursements for the past 3 years.
I invite your
Not
attention
the
to the
actuarial.
sorry. I invite your attention to the last paragraph. This also serves as a reasonable 2-year forward expenditure estimate because it represents the absorptive capacity of PhilHealth as an institution. The 2-year expenditure levels from 2018 to 2023 were relatively stable, almost unaffected by the COVID-19. This is the figures by which you arrived at 183.1 billion, correct?
Yes, Your Honor.
And therefore, that is your approximation of the 2-year ceiling, correct?
I guess that is so. Your Honor.
So again, to repeat, this is your computation of the ceiling in Section 11, correct? I see Senator Rector nodding his head. Correct?
Yes, Your Honor.
Okay. And in arriving at that, Ms. Nerissa, when you arrived at your figure, or when you look at the figure of DOF, this is a simple addition of actual expenses of 2018 to 2023 divided by 5. This is not an actuarial estimate.
That's correct, Your Honor.
Correct?
Yes po.
And the law says what is required is not an average of costs. What is required is an actuarial estimate. Correct?
Yes, Your Honor, but may I, the way I understand the Section 11 is that the actuarially estimated 2-year program expenditure projected is the ceiling.
Correct.
Yes, sir.
But they reduced the ceiling because they used their own formula, which I am now saying is not an actuarial formula. Is it?
Yes, Your
It is not.
Yes, Your Honor.
It is a straightforward getting the average of expenses for 5 years divided by 5 to come up with an average.
That's correct, Your Honor.
Correct?
Yes, Your Honor.
Are we in agreement, Mr. Solicitor General?
Yes, Your Honor, because Section 11 provides for a ceiling, so
Yes.
any amount can be less than the ceiling.
That's where we disagree. It says actuarial estimate. And the actuarial
Yeah,
estimate
for the ceiling.
given
For
by
the ceiling.
Yes. She gave an actuarial estimate for the ceiling. How much was that? 500?
560, Your Honor.
And your estimate is almost half. 200. Correct?
281, Your Honor, to
Correct.
be exact.
So my point, my question to the Solicitor General is, not using the actuarial figures for arriving at the ceiling violates Section 11, correct? That's what
Sorry.
Section 11 says.
Yes, Your Honor, but if Section 11 speaks of a ceiling, then it goes to show that the reserve fund may actually be at a lower level. And that's what exactly DOF
I'm not disputing that. I'm not disputing that. What I'm saying is that in computing the ceiling, you disregarded the actuarial estimate and imposed your own. Am I wrong in that?
Well, it seems that that
seems
was
that
the
I'm right.
manner that the DOF computed the
Yes.
ceiling. But again, the amount that would have to be remitted was based on a different formula.
I'm not yet there. If, Ms. Nerissa, if PhilHealth's total reserve funds as of 2023 is only 464 billion, then it has not reached the ceiling of 560.55 billion. Correct?
Yes, Your Honor. If it is compared to the 560, then it has not reached the ceiling, Your Honor.
again invite your attention to the highlighted portion of Section 11. If that can be flashed on the screen. The second paragraph. Provided further that whenever actual reserves exceed the required ceiling at the end of the fiscal year, the excess of the PhilHealth Reserve Fund shall be used to increase the program's benefits and to decrease the amount of members' contributions. My reading is that once we reach the ceiling of 2 years projected program expenditures, that triggers two scenarios. Increase the program's benefits, decrease the amount of members' contributions. Since you've been so familiar with Section 11, do you agree with my reading of this one?
Yes, Your Honor.
In fact, in the second paragraph of Section 11, it states there that any unused portion of the reserve fund that is not needed to meet the current expenditure obligations or support the aforementioned programs shall be placed in investments. I understand that to mean that until and unless the ceiling is reached, the reserve funds shall be placed in investments, correct?
Yes, Your Honor.
Can PhilHealth accumulate as much reserve funds as it wants?
It is limited to the ceiling, Your Honor.
Yes. The moment it reaches the ceiling, it triggers those two obligations, correct?
That's correct, Your Honor.
But until it reaches the ceiling, the mandate of Section 11 to PhilHealth is to continue maintaining and accumulating these reserve funds, correct?
That's as stated in the Section 11, Your Honor.
And the reason, the way I divine the reason, is for PhilHealth to gradually accumulate enough reserve funds to reach the actuarially estimated ceiling, correct?
That's correct, Your Honor.
So when the reserve funds exceed the ceiling, again, to repeat, to belabor the point, Section 11 mandates that the excess shall be used to increase benefits and increase the amount of contributions, decrease the amount of contributions, correct?
That's the way I understand it,
yes,
Your Honor.
So if PhilHealth's reserve funds remain below the ceiling, its obligation under Section 11 does not kick in.
Under Section 11, yes, Your Honor.
Section 11 also mandates, as you admitted earlier, that you would invest the reserve funds that are not needed to meet the current expenditures, correct?
Yes, as stated in the Section 11, Your Honor.
Okay. Can we go to the financial statement of PhilHealth's total reserve funds as of December 31, 2023? I see 464 billion as the reserve fund in 2023. Can you confirm that?
Yes, Your Honor.
On page 54 of PhilHealth's 2023 financial statements, can you flash the next slide? It is stated there that the ceiling or the amount actuarially estimated for 2 years projected program expenditures is 560.55. Correct?
Yes, Your Honor.
So since PhilHealth has not reached the ceiling at this time, legally, and if we follow the language of Section 11, no portion of its reserve funds can be used to increase benefits and decrease the amount of contributions, correct?
That's correct, Your Honor, as stated in the Section 11.
And since it cannot use, it has to invest.
Yes, Your
That's
Honor.
the mandate.
Yes, Your Honor.
And that's exactly what PhilHealth has been doing, correct?
Yes, Your Honor.
In fact, based on PhilHealth's 2023 financial statements, it has investments in time deposits amounting to 135 billion and investment securities of 336 billion, correct? That's the financial statements of PhilHealth.
That's correct, Your Honor.
And these investments generate interest income.
That's correct, Your Honor.
And of its reported income of 174 billion in 2023, PhilHealth generated around 20 billion pesos by way of interest income, correct?
That's correct, Your Honor.
So I guess where I'm going is that these reserve funds are actually not idle, are they?
That's correct, Your Honor.
They are earning income, correct?
Yes, Your Honor.
Now, drawing you back to DOF's computation of the 2 years projected program expenditures, if that were the ceiling, which is 280.6 billion, then it means that the ceiling has been reached.
That's correct,
Because
Your Honor.
reserve funds is at 464 billion. Correct?
That's correct, Your Honor.
And, sorry, thank you, Marisa. I will continue with Mr. Solicitor General.
Yes.
So this difference, Mr. Solicitor General, between the reserve funds and the DOF computation of 2 years is 183.1 billion.
Yes, Your Honor.
And that's what you call a fund balance, correct?
Fund balance.
Yes. The 89.9 billion that was taken from this.
Yes, from the 183 billion.
Okay.
Your Honor.
Now let's go to PhilHealth's financial statement for calendar years 2020 to 2023. Before any adjustment by the DOF, all of the money not needed for the current year's expenditures were actually placed by PhilHealth in the reserve fund. Correct?
Seems to be the case, Your Honor, but I'm not counsel for PhilHealth, Your Honor.
But you are counsel for DOF.
Oh, yes, Your Honor.
I'm showing you a screenshot of page 64 of PhilHealth's 2023 financial statement under the title Other Significant and Relevant Information. It is there stated that by virtue of special provision number 1D, the management took actions, and I quote, in order to comply with the said directive. Correct?
Yes, Your Honor.
And one of those actions was the reduction of 183.1 billion of the reserve fund and its transfer to the surplus fund, correct?
Yes, Your Honor.
So based on all of these, do you confirm that the 183.1 billion fund balance, as you call it, was originally part of the reserve funds? That's where it came from.
May I confer
Please.
for a second? Your Honor, as far as DOF is concerned, that is part of the accumulated revenues, but not necessarily of the
No, but I
reserve
just
fund.
showed you the table. The money came from the reserve fund, and it got transferred to the surplus fund by virtue of Section 1D. When PhilHealth Management decided to comply with Section 1D, it transferred 183.1 billion from the reserve fund to the surplus account.
Your Honor, there was a process before that because the initial step that has to be taken is to reduce the amount of the reserve fund to a reasonable level, taking into account the disbursements for the past several years.
So what you did was you had your own computation of what the reserve fund should be, and based on that amount, you took the difference and said that that difference should not be in the reserve fund and therefore should be transferred to the surplus account.
Yes, that is the remainder which is referred to in
So
Section 1D.
my ultimate question, Mr. Solicitor General, is simply that the 183.1 actually did originate from the reserve fund, correct?
Originally, yes, until Section 1D
Exactly
of the
my
special
point.
provisions.
Yes, exactly. Can I go back to Section 11? Again, the same proviso. Whenever actual reserves exceed the required ceiling at the end of the fiscal year, the excess of the PhilHealth Reserve Fund shall be used to increase the program's benefits and to decrease the amount of members' contributions. Do you agree with me that the language "shall be used" is mandatory?
Yes, Your Honor.
In other words, using the figures of DOF, the excess of the reserve fund amounting to 183.1 billion should, by Section 11, should be used to increase benefits and to decrease the amount of members' contributions. That's the language of Section 11. Can we agree on that?
Your Honor, I have to qualify my answer. The implementation of the UHCA is for a period of 10 years. There is no statement in Section 11 that that mandate has to be done immediately the following fiscal year. But it could be done within the remaining period for the implementation
Understood.
of the UHCA.
But every time you take money away from the reserve fund, the reserve fund is not able to reach the ceiling. So the movement towards reaching the ceiling to trigger these benefits and the reduction of contributions will get retarded.
There are many policy considerations.
I'm talking about law.
Yes, Your Honor, that is very true.
That's where I'm going, Mr. Solicitor General. The way I see it, there is a specific design in Section 11 in that there will never be any unused portion of the reserve fund that can be taken. If the 2 years ceiling is not reached, the reserve fund shall be deposited. If the ceiling is breached, then the excess is mandated to be distributed. That's the design of Section 11. Pretty good design, if you were to ask me. Can we agree on my interpretation?
Yes, Your Honor. Subject to, policy considerations by the Board of Directors of PhilHealth.
Do the policy considerations involve violating the mandate of Section 11?
No, Your Honor, because Section 11 speaks of a ceiling.
Yes, and the moment you reach that ceiling, there is a mandate, shall be used.
Your Honor, there is no command for
Shall
the
be used.
PhilHealth to reach the ceiling projected actuarially. There is no such
But
command.
that's the design. That's why we're doing it in 10 years, to allow them to accumulate enough funds. And the moment you take those funds away, you retard the 10-year period. And now in 2025, there's not even an amount given.
There are
That's where
policy
I'm coming from.
considerations, Your Honor. I'm sorry, but I understand what the law is providing, but I also have to take into account policy considerations, management prerogatives, what amount to include in the benefit package, when to give it, and so forth and so on.
Right.
Those are management prerogatives, Your Honor.
The way I see it, and again, I'm sharing to you my understanding of the law, is there is an impetus to reach the ceiling as soon as possible. Why? To trigger the benefits, to trigger the lowering of contributions. I say that because I also contribute.
Your Honor, I am also a contributor.
I know.
But what I'm trying to say here is PhilHealth can do such thing, increase the benefit packages, even if the ceiling is not yet reached.
Okay. We will agree to disagree agreeably. But the way I've described the design of Section 11, don't you agree that it signals how special these funds are? Because if they were to be treated as not special, then I'll never reach the ceiling, will I?
Your Honor, as long as we get the necessary benefit packages that we are entitled to, then I don't really mind whether we reach that
It's not
ceiling
just
or
the benefit packages, it's the reduction of contributions.
Regarding that matter, we have submitted to this court our position that the matter of reducing the premium contributions is something for the legislature to do.
Which
As a
they
matter
did.
of fact, there are bills
That's
pending.
what they did. Section 11. That's what they did.
No, I'm talking about the matter
To reach
of
the ceiling,
reducing
you
the
reduce
premium
my
rates.
contributions.
Yes,
That's
Your
the
Honor.
design.
Yes, Your Honor, but the UHCA speaks of a schedule until 2025 only. That's why in Congress there are pending bills to specifically address what will happen after 2025. Since there appears to be enough money in the treasury of the PhilHealth, then it's time to reduce the rates of premium contributions. And that's what exactly the Congress is trying to do now.
Again, like I said, we can agree to disagree agreeably.
Thank you.
Let me transfer now to a different issue altogether. Special provision number 1D of the 2024 GAA, was this in the House version of the bill?
I have to check on that.
Well, I can tell you it's not. It's not also in the Senate version of the bill.
Then it must have arisen from the bicameral conference committee.
Correct. My own research is that there are no provisions in either the House or the Senate version which deal with the grant of authority to the DOF to return the fund balance. I'm showing on the screen a copy of the BICAM report on special provisions. I think I got this from one of your submissions. According to this, it says, insert new item. Again, for the record, do you confirm that this is a totally new provision, not found in either the House or Senate version of the bill?
Yes, Your Honor, it is. It is what it is, as stated in the report.
So if there are no provisions, there is no conflict that needs to be reconciled, correct?
There are certain other items that were taken up by the bicameral conference committee pertaining to certain amounts where the House and the Senate had disagreements. But this one is not one of them. This is a new provision.
So totally new?
Yes, Your Honor.
It's not meant to reconcile anything?
That's correct, Your Honor.
Okay. Can I go to Article 6, Section 26, Paragraph 2 of the Constitution? Can you flash that? Sorry. I will read it. No bill passed by either house shall become law unless it has passed 3 readings on separate days and printed copies thereof in its final form have been distributed to its members 3 days before its passage, except when the President certifies to the necessity of its immediate enactment to meet a public calamity or emergency. Upon the last reading of a bill, no amendment thereto shall be allowed, and the vote thereon shall be taken immediately thereafter, and the yeas and nays entered in the journal. Do you agree, Solicitor General, that these requirements of the Constitution are mandatory?
Yes, Your Honor.
And in fact,
subject to the exception. Sorry.
And these requirements ensure, in fact, the transparency that the legislators as well as the public are informed of the provisions of the bill, correct?
That is correct, Your Honor.
And these constitutional requirements apply to both houses?
Yes, Your Honor.
And these congressional sessions where they discuss the bill, they are open also to the public, correct?
Yes, Your Honor.
So let me digress for a moment. Earlier, we talked about the syntax laws and its amendments. These syntax laws were crafted by Congress over a certain period of time. For example, Republic Act 9334 was a House bill originated from the House of Representatives and first filed on October 26, 2004. It was certified as urgent, but both houses studied the proposed measure until it was signed into law only on December 21, 2004. That is a period of 2 months. For RA 10351, the Senate Committee on Ways and Means conducted several hearings on the proposal to restructure syntaxes. These were on August 16, 23, 30, and September 20, 2012. Again, the committee referred the proposed measure to the plenary on October 9. The Senate considered the proposal, and it was finally signed into law on December 19, 2012. 4 months per my count. The syntax reforms enacted afterwards, same. Initial proposal was heard on February 4, 2019, approval on May 27, 2019, 4 months. In the Universal Health Care Act, it underwent a longer period of consideration, with the Committees on Health, Demography, Ways and Means, Finance endorsing both its initial hearing on February 1 and eventually endorsing the measure for approval of the Senate on July 30, 2018, and finally signed into law as 2019, meaning it took more than 1 year to finalize the UHCA. That's a brief digression. I'll go back to that. When each House of Congress goes through the legislative process of crafting bills for the same subject matter, it is only natural that what was approved by the other House might be different from what was approved by the other, correct?
Yes, Your Honor.
And that is why we have the BICAM committee.
Exactly, Your Honor.
Exactly. To settle differences between the two versions, correct?
Among others.
Is the BICAM a constitutional creation?
I think it is created by the internal rules of Congress.
Yes. Can we flash that? It's created by Section 35, Rule 12 of the 2023 Senate Rules. These are the more recent ones. And for the House of Representatives, Rule 9, Section 62. And if you look at the highlighted portions, the purpose for the creation of the BICAM committee is to settle differences. Are we agree that that is the source of the power of the BICAM?
Yes, Your Honor.
Okay. So, to be clear, the BICAM is merely a creation of both houses of Congress, correct?
Yes, Your Honor, pursuant also to a constitutional provision that allows both chambers of commerce, both chambers of Congress to enact its own rules of procedure.
But being a creature of both houses, it only has delegated authority, correct?
Yes, Your Honor.
And if it only has delegated authority, can the conference committee perform functions that Congress itself cannot do?
Subject to ratification by both chambers, Your Honor, yes.
So the spring can rise higher than the source?
No, I'm not saying that, Your Honor. What I'm saying is whatever the BICAM comes up with is subject to ratification by the original chambers.
But whatever BICAM comes up with, like the insertion, the 1D, that is not subjected to the same 3 readings I read earlier, right?
Definitely not, Your Honor.
It is not subjected to the discussions, the deliberations.
Yes, Your Honor. That has already been delegated.
It's
to the
also
members
not
of the
subject to scrutiny by the public. Correct?
Well, the members of the House of Representatives and the Senate, the senators, are representatives of the people, Your Honor. Once they act on it, they are acting in their sovereign capacity as representatives of the people.
These are specific individual legislators. They're not Congress. They're just a creation of Congress.
Yes, Your Honor, but as I said, whatever they come up with will have to be ratified by their original chambers, by the House and by the Senate.
Let's go there. Is there a requirement under the respective rules of each chamber to provide copies to members within a certain number of days before the session, before it is taken up in the session?
I think that is provided for in the internal rules of Congress, Your Honor.
And actually, we don't find it. But under the rules of the House, it says in the last 15 days of each session period, that is the period where the GAA is actually approved. It is enough that copies of the reconciled version be filed with the House Secretary General.
Yes, Your Honor. That is part of the rules.
And a proposed GAA would normally have voluminous records, correct?
Yes, Your Honor.
So would you agree with me that in reality, there is no real opportunity for an individual legislator to review the reconciled version that will be submitted to the President?
Your Honor, I would not be in a position to answer that because that calls for a speculation. I wouldn't know what's in the mind of this individual congressman. if they actually, religiously, and diligently studied.
So you say
the
that there
report
is a
of the
real
BICAM.
opportunity. There is a real opportunity for an individual legislator to study the voluminous records of a reconciled GAA.
They
That's
will-
your position.
Your Honor, they will just have to take a look and examine the BICAM report, because that is what they are going to ratify or affirm. They don't have to go back to each and every item, the thousands of items originally included in the GAA, in the General Appropriation Bill. Otherwise, they won't be able to finish.
Article 6, Section 1 of the Constitution provides that legislative power shall be vested in Congress. Is this legislative power lodged in Congress as a body or in individual legislators?
In the body, of course, Your Honor. In
So
Congress.
individual legislators cannot exercise legislative power by themselves,
Yes,
correct?
yes, Your Honor.
This is my final question, and this is where I had digressed earlier. We have seen the many years, from 2003 all the way up to 2019, of discussions, staff work, interpellations, deliberations, extensive and thorough study in order to come up with a Universal Health Care Act. A law that, in my view, has a particularly good design in establishing funding and sustainability. And all of that, all of it, gets undone by a one-sentence insertion in the 2024 GAA. Don't you think there is something wrong in that?
Your Honor, we are saying that Special Provision 1D did not violate any provision of the Universal Health Care Act. And that's why we have been discussing these issues with the Honorable Court.
That's all. Thank you so much. Thank you.
Thank you, Justice Kagiwa. Justice Jolo Lopez will conduct his interpellation.
Thank you, Chief. May I call on any of petitioner's counsel to the podium to answer some of my questions?
Your Honors, please, we divided the topic, so it depends on what topic, Your Honor. If it's PhilHealth, Your Honor, Attorney Pao.
I think you can answer all my questions. I'm sure of that. Attorney Colmenares, you're running for congressman, isn't it?
Yes, Your Honor, I'm running.
I've always voted for you, but I'm not sure this time because I do not know your party list.
Bayan muna, Your Honor.
Anyway, Mr. Congressman, may I call also on any representative from PhilHealth who understands some accounting procedures? You see, we lawyers do not understand much about accounting procedures, but I'm not talking in behalf of the whole court, because many of my colleagues, they know accounting very well. So can I ask any representative from the PhilHealth to answer some of my questions regarding accounting procedures? Now, Congressman, Mr. Counsel, can I call you Congressman already, Mr.
Not
Counsel?
yet, Your Honor.
Not yet. Now, Mr. Counsel, may I know if you know any of the petitioner organizations or even members of any petitioner organization may have claims whose claims may have been denied by PhilHealth before or even after the fund transfer?
Yes, Your Honor, we have some reports already previously about denials of certain claims, Your Honors. And not among the petitioners, but associations and other groups,
But you
Your
have
Honors.
not made any allegations to that effect. From my own reading, many of the allegations are general, that they may suffer as a consequence of the fund transfer. But there was no specific instance of denial made by PhilHealth with regard to their claims made to the PhilHealth.
Your Honors, Our petition, actually, Your Honors, is simply on Section 1D, that 1D is void because of the insertion of the BICAM, and anything that flows from it is void.
We'll go
The
into that,
PhilHealth issue, Your Honor, if I may, is the topic of the petition of Pimentel, Your Honor.
Yeah.
We did not touch.
Probably we
Maybe,
can call on the counsel
yes.
of
Yes, please.
Senator Pimentel.
Because they're, yes, Attorney Pao.
Now, if I may be allowed to narrate my own personal experience with regard to PhilHealth. You see, 2 years ago, I was stricken of a esophageal cancer, which went into my lungs, and I had to be confined for more than 2 months in one hospital in Metro Manila. And if I recall it correctly, my bill runs up to almost 7 million pesos. And would you know how much of it was covered by PhilHealth? Can you make a good guess, Counsel?
Good afternoon, Your Honor. If I may, Your Honor. I am pretty sure, Your Honor, it is not more than 10%. But I cannot
definitely much lower than
Yes, Your
10%. It's only 50,000. I don't know how to compute it, but I'm sure it's less than 2%. But the problem does not end there. When I had to do some regular procedure after the operation, they call it dilation. They have to expand my throat and my esophagus. And every time I do that procedure, I have to spend more or less around 40,000 pesos. And I went to see PhilHealth. Personally, I asked how much can be covered by PhilHealth. And PhilHealth told me, I've run out of money. They cannot answer any of the 40,000 that are, despite the fact that I've been regularly paying PhilHealth for the last, how long has it been in existence? I've been in government service for more than 40 years. I started working for the government in 1985. So my question is really actual charge and the rate, case rate. I think PhilHealth call it case rate. Actual charge is the hospital bill being charged by the hospital. And case rate is the amount to be covered by PhilHealth. So what, may I ask, can I get your name again?
Magandang hapon, Your Honors.
Yes, magandang hapon din.
SVP Renette
SVP,
Limsiaco of
Senior
the Fund
Vice
Management
President of
Sector.
PhilHealth.
Yes,
You're
Your Honor.
also member of the board of PhilHealth.
No, Your Honor.
No, SVP. So, Mr. SVP, what's your last name again?
Limsiaco, Your Honor.
Limsiaco. Lawyer or not?
No, Your Honor.
Mr. Limsiaco, on the average, I'm sure you have been with the PhilHealth for a long period of time. What is the average case rate? Meaning, let's say, if a Filipino will have to be treated for tuberculosis and he incurred an amount of 200,000 pesos, I think that's a regular estimate, normal estimate. How much of it will be covered by PhilHealth?
Your Honor, again, the case rate of PhilHealth varies. Now, as to the question of the average
Yes. On
case
the
rate
average,
po, batay sa pumapasok na claims and the case rate na bill po, our computation before is nasa 10,000 pesos. But recently, Your Honors...
10,000, that's around 5% if I...
Yes, Your Honors.
Computed it correctly, around 5%.
Recently, Your Honors, after the 2024, Your Honors, of
After
the increased
case has been
case rate,
filed with the Supreme Court, the case rate has been increased.
Increased na po 2024 po, starting 2023 actually. And then 2024, grabe yung increase ng case rate ng PhilHealth. We have 30% in February 2024 and another 50% by December 2024 po. The average value of case rate increases po I think nasa 13 or 13,000 pesos or 14,000 pesos already.
That's good news for all the PhilHealth members. Mali lang timing ng pagkakasakit ko. Dapat nagkasakit ako now than before. So anyway, we'll go back to that issue. Let me digress a little, no? Yung universal healthcare, no? Kasi we're talking about Universal Healthcare Act. Ang intention was to minimize out-of-pocket expenses of one Filipino family.
Yes, Your
Meaning, no Filipino family should suffer as a consequence of one sickness.
Yes, Your Honor.
So you think 5 to 10% would be sufficient for one Filipino family to avoid suffering from the consequences of one sickness and suffer economic difficulties?
Your Honor, of course, hindi, Your Honor. That's the reason why PhilHealth, through our board of directors, Your Honors, increased the case rate, Your Honors. Again, the one I mentioned a while ago is not only the increase of PhilHealth, Your Honor.
What would be the ideal case rate?
Your Honor,
Mr. SBP.
Again, based on the cases po ito, and in case of the breast cancer, Your Honor, in-increase po ng PhilHealth last year from 100,000, Your Honor, to a maximum of 1.4 million, Your Honor. So, ganun po siya, Your Honor. And
breast cancer to?
Opo.
So 1.4 million out of how much hospital charge?
Your Honor, well, depending on the actual charge of the hospital.
It will
but
not
PhilHealth
go
will
beyond
cover.
10 million, so around 10 to 15%.
Again, Your Honor, on the part of the breast cancer, 1.4 million is the maximum, Your Honor.
But
that
you have read I suppose you have read the Universal Healthcare Act.
Yes, Your
What will
Honor.
be the ideal case rate so that the intention of the law will not suffer, meaning no Filipino family must suffer as a consequence of one sickness?
Your Honor, PhilHealth's target for year 2025, Your Honor, is 18%, Your Honor, mako-cover po niya.
18% would
Yes,
be
Your
ideal
Honor.
already.
Yes, Your Honor. For year 2025, Your Honor.
Hindi ba kailangan mga 50%? We will not be able to reach that point?
Your
You
Honor,
think?
as we progress the implementation, Your Honor, and of
In
course,
the coming years.
But mayroon ho National Health Financing Strategy that set up, Your Honor, through our Department of Health, Your Honor. 2028, Your Honor, PhilHealth's gonna cover 26, 28. If I'm not mistaken, Your Honor, that's 28%, Your Honor.
28. Bakit di na lang natin sabihin 50%? Ideal lang naman eh.
Your Honor, there are some instances, Your Honor, that actually PhilHealth covers that one, particularly in cases in the government hospital. When I say government hospital, Your Honor, we have the Department of Health, and of course, Your Honor, on the part of our local government hospitals, Your Honor.
Okay.
So we have also that no balance billing, Your Honor, implemented in the government hospitals, Your Honor. Meaning,
That would be
wala
nice
na po,
to hear. No hospital billing already.
wala na po babayaran ang ating mga pasyente po on those hospital po, on their hospital
may I
bill
ask
po.
Counsel? Now, you were talking also about transcendental importance. You're pointing to another lawyer, but I think you will be able to answer my question. I'm not even asking about... I would like to cite one case decided by Senior Associate Justice Marbiclion and the case of falsis. There must be some form of injury in fact. That's why I asked my first question. There must be somebody, part of the petitioners, who may have suffered, meaning whose claim may have been denied. All I get are general allegations on your part that they may suffer consequences as a result of the fund transfer. But anyway, going to another issue, transcendental importance. Then there's another case decided by the court which says that you can bring up cases involving transcendental importance to the court directly only if involves questions of law. Do you think this case involves only questions of law? Or it involves question of law and questions of facts?
If I may, Your Honor, I believe, Your Honor, this involves questions of law, Your Honor, because the petitions actually questions the constitutionality, Your Honor, of the assertions,
But
Your Honor.
what if we finally decide, granting lang for the sake of argument, that we decided to resolve this case by saying that Section 1D and DOF circular are valid and constitutional? Then we may have to go to the issue, factual issue, as to how the government arrived at the amount of fund transfer, which in this case amounts to 89.9 billion. Correct, Madam Counsel?
Yes, Your Honor.
So it's a question of facts. Now, do you think, because the government makes it look easy for the Supreme Court justices to understand, but I don't know if the accounting process is correct or not. So if I may ask you, are you an accountant?
No, Your Honor.
No, but you understand a little about accounting.
Just a little, Your Honor.
Now, you know how they arrive at 89.9?
Yes, Your Honor.
How?
They actually, they were able to present this, Your Honor, in several congressional hearings. They computed it based on what the government paid for a subsidy for indirect
Yes,
contributors, less the payments for claims for indirect contributors for the years, Your Honor, 2021
to 23.
Yes, Your Honor.
So, very simple eh. And you agree with that. Subsidy in the form of involuntary contribution of involuntary members minus the claimed benefits, not of the voluntary contributors, but limited only to involuntary members. And that will amount to fund transfer or excess fund. Do you agree with that accounting process? Then we'll ask the government lawyer to explain it to us.
We actually do not agree, Your Honor.
Huh?
We do not.
Why do you not agree?
I think, Your Honor, it is clear under the universal health care that these funds are actually, and there was a submission by PhilHealth admitting that these funds are actually there is a one-fund policy wherein you do not necessarily separate the funds that was paid for as premiums of indirect contributors versus those that were paid for by the direct contributors, Your Honor.
But that would make the case more complicated. Why make a distinction? Why not agree with the government? We shall allow Mr. SBP to answer the question. Why
Yes, Your
limit
Honor.
it to involuntary contribution minus the claim of involuntary contributors? Now, if I may ask you first, sir, what is the bigger portion? The premiums paid in the form of subsidy by involuntary contributors or the premiums paid by the voluntary contributors vis-a-vis the claim benefits of voluntary contributors as against the claim benefits of voluntary contributors?
Your Honor.
And why we have to make a distinction? And finally, so you have all the time to answer my question. Finally, the government decides to have the fund transfer limited to 2021 to 2023. Why not go back to 2010? Wala bang remaining balance in 2019 which were not used, which were not expended, which are unrestricted? Why limit it only to 2021 to 2023?
Your Honor.
Yes, please, sir.
On the part of the classification of members, Your Honor, there are two. We have the direct contributors and we have the indirect contributors. The money that that we transfer back to the national government is the money from the indirect contributors, meaning these are contribution or subsidy by the national government to the sponsored members, indigent, support, and so on, Your Honor. Now, Your Honor, the transfer is limited only to the indirect contributors, Your Honor, because, Your Honor, hindi naman po binabalak ng national government itas yung direct contributors, which are money from the paying members, Your Honor. And Your Honor, bakit 2021 to 2023?
Bakit una, ano ba mas malaking claim benefits? Voluntary contributors or involuntary contributor? Because how you arrive at 89.9 is to deduct only the claim benefits of indirect contributors. Why not include the claim benefits of direct contributors? Baka wala nang matira.
Your Honor, again, dalawa to, direct and indirect. That's the
Yes.
reason why in the calculation, Your Honor, the calculation only speaks about the indirect contributors, meaning contribution on the part of the national government subsidy, indirect contributors, and on the part of the expense as well, Your Honors, only for the expenses of the indirect contributors as well. Kumbaga, apple to apple ang calculation, Your Honor. Now, that's
Pero ano
the
mas malaki? Claim benefits ng involuntary or involuntary contributors?
average, Your Honor. The direct contributors yung mas malaki ang ating
Direct contributors.
benefit po.
Ilang
Average.
percentage yun? More or less?
In the past, Your Honor, that's 60-40 po to.
60-40. And
Opo.
would you say there is also fund balance when it comes to direct contributors? May fund balance din ba?
Yes,
Which is even
yes,
bigger.
Your Honor.
Because the contribution, the premiums being paid by the
direct
are
Yes po.
bigger. So that means to say there is a bigger fund balance available for the use of the government.
Yes, Your Honor. Mas malaki po ang sa direct.
So kung kinompute nyo dalawa, mas malaki pa kalalabasan na ito. Not only 89.9.
Yes, sir. Yes, Your Honor.
Magkano kalalabasan na ito? How much will, if you compute both the claim benefits of voluntary and involuntary contributors? Do you have any idea or how much of it?
Your Honor, as to the calculation on the accumulated revenue, Your Honor, our calculation ay on the part of the direct nasa 1.6 billion, Your Honor. On the part of the indirect nasa 100.3 billion, Your Honor.
So hindi na ninyo ginalaw to, you are only touching on the amount belonging to the involuntary contributors.
Yes, Your Honor.
Kawawa naman yung involuntary contributors. You've returned the money to the general fund. Do you think it would reduce the benefits that should go to the involuntary contributors?
Your Honor, the benefit of PhilHealth and ay pare-pareho po ang na-avail
Walang
even year.
pinagkukunan.
Yes po.
Accounting procedure lang yan.
Yes.
Accounting processes.
Yes po.
Meaning, even the premiums being paid by voluntary contributors may be used to answer for claim benefits of involuntary contributors.
Yes, Your Honor.
Are you sure of that, Mr. SBP?
Your Honor, the benefit claims of direct and indirect the same, pareho po sila. And ano po to, year 2025 po, I still continuously build of the benefit ng ating direct and indirect contributors, Your Honor.
When you say fund balance, dating back as far back as 2021, are you telling me that PhilHealth did not and was not able to make use of the money available to them?
Your Honor,
Were you part already of PhilHealth during those days? 2021?
2021, Your Honor, nasa PhilHealth na ako.
Naku,
Year 2001, Your Honor,
baka
nasa
we can
PhilHealth
make
na
you
po ako.
accountable for that. So you meaning to say you were not able to make use of the money available to you at that time?
Your Honor, all these things, Your Honor, ay papasok siya sa accumulated revenue, Your Honor.
So it may be spent to invest or to make use of
In the benefit expansion improvement, Your Honor, that we are doing right now, Your Honor.
You were saying the government is telling us now that since 2021, the available funds available. Parang doble, ano. The available funds in 2021 amounts to, may figure ako eh. Basta every day for the 3 years, it's 89.9. These are idle funds, unrestricted, unexpended, unused.
Your Honor,
PhilHealth can be held accountable for that, for not making use, and the government right now is correct.
Your Honor,
And,
during the
Secretary Rector is nodding. The government might not be correct in the past that they were not able to make use of this money to increase the benefits during those days. Instead, allow the money to stay idle, so the government has to make use of the money now instead of borrowing funds from other sources, which the government has to pay some kind of interest. Why not make use of our own money and spend it for other appropriations? Now, whether the appropriations program is another issue, but we may not be able to touch it because my time is limited. But the point is, are you telling us now, Mr. SBP, that the government failed to make use of the money available at that time? It's sitting idly on the side or invested in some other things that you want to make use of it now. That's why you have to invest it or to put it in the government coffers to answer for some unprogrammed activities or of the government?
Your Honor, year 2021, Your Honor, nasa pandemic po tayo. 2021, 2022, Your Honor. Again, of course, nag-start sa year 2020. So during those years, Your Honor, yung ating availment ay hindi siya pareho sa mga panahon na hindi ho tayo pandemic. And the national government subsidy, Your Honor, ay tuloy-tuloy po yung labas ng pera. And tuloy-tuloy po yung receive ng PhilHealth ng pera on that year.
May fund balance ba 2019 o 2020? Wala, zero?
Your Honor, during those years, Your Honor, pumapasok po siya sa reserve fund po natin as presented earlier, Your Honor.
Pumasok na sa reserve fund. In 2021, di pumasok sa reserve fund. That's why it's sitting idly in the bank perhaps. And who's earning interest out of it? You know, I used to be part of PhilHealth. Many do not know, but during the time of Secretary Estrella, I was a legal consultant. It was during those days that PhilHealth was being organized. In fact, we organized it during those days at the regional level. Kami nag-organize yan. We put in some good people to run PhilHealth. So meaning to say, Mr. SBP, hindi tayo pwede mag-inhibit eh. Nandito na. Mr. SBP, ganun ba yun? Hindi nagagamit yung pera? 21, 22, 23?
21, 22, 23, Your Honor, ginagamit naman ang pondo. We are using the money. But of course, Your Honor, because of the pandemic, bumaba yung availment ng
kaya
benefits.
Ng reserve.
Oo. And the premium, Your Honor, is legislated. Ibig sabihin, tuloy-tuloy because nasa batas po siya. And including, Your Honor, the national government counterpart or the national government subsidy ay pumapasok po sa PhilHealth.
Do you agree with that, Counsel?
If I may, Your Honor. Actually,
you can call the others,
Yes.
other counsel. They knew for a fact that there is something wrong with the accounting procedure being made by the government.
Yes,
they
Your
make
Honor.
it so simple. We understood it, but we do not know if it's the correct procedure.
Yes, Your Honor. If I may, Your Honor, with the
Yes,
permission of the
Counsel,
court.
please.
Even assuming, Your Honor, for the sake of argument that the computation of the government is correct, Your Honor, and which I actually disagree, Your Honor. We disagree, Your Honor, because as we said, this is a social health insurance which should be covering a one fund policy. But if you look at it, Your Honor, as mentioned by assuming, Your Honor, that the computation is correct, from 2016, Your Honor, to 2020, the indirect premium contributions less indirect benefits claim actually all yielded to negative. meaning it was the premium contributions of the direct contributors that were actually used to pay for the negative of the indirect contributors, assuming it is not one fund under the social health insurance. So if you compute it, Your Honor, at least my data is only from 2013, Your Honor, when the Republic Act 10351 was passed. It appears, Your Honor, that PhilHealth, from indirect premium contributions versus indirect benefits claim, it was only in the years 2014, 2015, 21, 22, and 23 that there was actually excess. But all the years, it yielded negative. So in short, Your Honor, that is why our argument, Your Honor, is really that based on a social health insurance, this funds is actually one fund, because even if the premium contributions for indirect contributors are less than what the government pays for the claims of the indirect contributors, they never once paid additional, or the Congress never once made additional subsidies, Your Honor, which is also available under Section 10 of Universal Healthcare Act. But it never once did, because these funds, once it goes into PhilHealth, is considered as a one fund, whereby the direct contributors' premiums and the indirect contributors' premiums are actually joined together. Yes, Your Honor.
You're an accountant, Mr. SBP.
Yes, Your Honor.
So, you agree with the explanation?
Your Honor, they have the different figures from ours, Your Honor.
So, which is the correct figures?
Of course, Your Honor, we have the data.
You're confusing me.
We have the data, Your Honor.
You have the data, they do not have the data.
Your Honor, as presented a while ago, they have the data as well, Your Honor.
They have the data, but not the correct data.
Your Honor, we have the data, we have the information.
Well, anyway, you will present your position paper later on.
Yes, Your
Just
Honor.
allow us to look into your data.
Yes, Your Honor.
But present to us why it is necessary to make a demarcation or bifurcation or whatever you call it, division between the involuntary contribution and the voluntary contribution. That is something I cannot understand. The voluntary, involuntary contributions, why you get fund transfer. And you were telling me a little earlier, if we include the contribution of the voluntary contribution, it would even amount to a bigger fund transfer. So you can even transfer a bigger amount than 89.9. Now, if we include the involuntary or voluntary contribution for the year 2021, 22, 23, that will be how much money will be going to the general coffers of the government. If we include the voluntary contribution, because of the pandemic, we were not able to utilize all the money during those days.
Your Honor.
It's even bigger.
Yes, Your Honor.
Because the division you said 60-40, 40 only pertains to the involuntary contribution. So just please explain it to us. We don't have that much time, but I hope the next time, God forbid, if we get any kind of sickness, I would not be getting only 2% of my total bill, because we want the intention as made in the Universal Healthcare Law. No Filipino family should suffer economic difficulties as a consequence of one sickness. It's so good. In my case, I have my Supreme Court colleagues, justices of the Supreme Court, who had to shell out from out-of-pocket money. They shell out money just to help me. And it's not from PhilHealth. I got some money also from our healthcare provider. But bulk of it, I got it from the Supreme Court justices who are more than willing to help a colleague. Thank you, Chief Justice and the justices. So, thank you, counsels. Thank you for your time, and thank you for patiently answering my questions.
Thank you,
Thank you, Your Honors.
Thank you, Justice Jolo. Justice Ricardo Rosario will interpolate.
May I request Attorney Colmenares, Congressman Colmenares, to please take the podium. Justice Amy Lazaro Javier has virtually covered all aspects of this petition during her allotted period of interpellation.
Yes, Your Honor.
I, for one, have questions of my own, but all the points I wanted to raise have practically been addressed or covered by our colleagues' splendid and comprehensive interpellation of the stakeholders in this petition. Do you agree, Congressman?
I would
Yes
like
na lang,
to
yes
think
na
so,
lang.
Your Honor. Our petition, just to clarify, Your Honor, is about presidential immunity, presidential certification of emergency. Can Congress increase the budget? And can the BICAM insert provisions? Of course, PhilHealth will be affected once, if we win our arguments that these are unconstitutional acts, Your Honor. With regards to the PhilHealth issue, I think more has to be explained also later on about the impact of
So you do
this.
not agree that that Justice Amy's interpellation was comprehensive?
Very comprehensive, Your
Okay.
Honor. Yes.
Now, in fact, Congressman, I'd like to express my gratitude to Justice Amy for capsulizing the issues involved in the instant petition. In the process, I have to admit this, making my job much easier. Our job, for that matter. Now, if I may share with you my observation, Congressman, a lot of people were in fact impressed by her intelligent, incisive, and thought-provoking questions. Of course, you cannot ask intelligent questions if you're not intelligent. And if
agree,
you
Your
did not
Honor.
intelligently analyze the issues of the case. What Justice Amy did is indeed a tough act to follow. Kudos also to the other justices who have followed suit. Incidentally, Justice Amy, if I may reveal, she is the chairperson of the 2025 bar examinations. Yours truly is 2027. Now, if the manner of conducting the examination of the parties in this oral argument is any indication of how the bar questions would be formulated, nakita niyo naman, Congressman, pati mga bar top-notchers dito, top-notchers, nahirapan sumagot.
Yes, Your Honor. Kahit ako, Your Honor.
Okay. Ang masasabi ko lang, good luck na lang sa ating mga bar examinees. They will need me very badly. Kasi kailangan nilang magrosaryo. Levity aside, Congressman. I have a question for your client, Attorney Colmenares, and the other petitioners may, they may also respond should they desire. I have prepared and have written down some of my queries in advance. Last week pa ito to make for a streamlined interpellation. And also, to save time for the other members of the court who have signified their desire to also conduct their own interpellations. Marami pa, mahigit 10 pa yung nakapila. Now, this is my question. Please pay attention. During Justice Amy's, ano ba ito? Amy's interpellation of Solicitor General Medardo Guevara, the projects or programs to which the excess funds of GOCCs would have been eventually devoted were discussed. Now, it appears to me that the appropriations in general, or rather that the Solicitor General was of the opinion, you were there, you heard him, that the allocation of budget or of appropriations in general is a matter that pertains to the wisdom and, by assumption of course, not to the legality or validity of the congressional statute. To avoid any chance of misinterpretation, I am quoting verbatim that particular portion of Justice Amy Lazaro's and Solicitor General's question and answer. I think, I'm not sure about how much time they have allocated for me to do my interpellation. Doblehin ko lang yung kay Justice Amy. 3 araw eh. Anyway, this is, sabi ni Justice Amy, the PGN Bridges project appears to be fully funded by the Export-Import Bank of Korea in the amount of how much? 174.49 billion plus. Is there an urgency to transfer the PhilHealth funds when the project is already funded? Solicitor General Guevara responded in this manner, Your Honor, this is a matter really of delving into the wisdom, again, into the wisdom of the legislature in allocating funds. When Justice Amy Lazaro Javier stressed the apparent anomaly in sourcing funds for a project for which funding has previously been made available, Solgen Guevara answered, Your Honor, one consideration by the Congress in doing so is a determination of when a project is already implementable. So if a project that has already been identified and sufficiently funded is considered to be non-implementable for the given fiscal year, then I think, this is Solgen Guevara speaking, di ako then I think he can more or less validate and confirm if I quoted him accurately and correctly. Then I think it is the decision of the Congress in the exercise of its policy or wisdom, so to speak, to move it to the unprogrammed appropriations for the meantime. Okay? Now, a principle in political law is that the court cannot generally question the wisdom of the statutes passed by the Congress. Tama?
Yes, Your
Whether
Honor.
a law enacted by the legislature branch is wise or would effectively realize the objective for which it was passed in the first place is a question that is virtually beyond the ambit of the court's jurisdiction as spelled out in our Constitution.
Yes, Your Honor.
If my understanding, Congressman, is correct, Solgen Guevara is arguing that allocation of funds is basically a political question and thus cannot be the subject of inquiry by the judiciary. Now, Attorney Nery Colmenares, as a former member of the House of Representatives who should be familiar with budget allocation under the General Appropriations Bill or Act, what is your take on this matter? In other words, can you comment on how congressional wisdom, as mentioned by the good Solicitor General, may override the prohibition against the use of PhilHealth funds for other matters or projects, such as infrastructure projects, peace negotiations? I think the Panay Guimaras Negros Island, BGN Island Bridges project was also cited. Go ahead.
Thank you, Mr. Chair. Yes, Congress always has a discretion in the wisdom of a law being passed, not just the budget, Your Honors, please. However, there are constitutional parameters to the exercise of that power, Your Honors, please. For example, the allocation of funds to these projects transferred to the program funds, for us, Your Honor, was not an act of Congress actually, but was an act of the bicameral committee, Your Honor, please. And under a constitution, it says that bills for appropriation bills should originate exclusively from the House, but the Senate may concur or propose amendments. In this case, Your Honor, the projects found in like the PGN Bridge in the unprogrammed fund did not come from the House of Representatives. The 281 billion for the unprogrammed funds was actually approved by the House, and the Senate concurred in that. Now, the insertion of the BICAM, Your Honor, of these projects, transferring it to the unprogrammed appropriations, even overstepping the 281 billion recommended for appropriations by the President, is a violation of the Constitution. And whatever projects they would put in there is already void because the BICAM Commission, Your Honors, please, has no power to originate an appropriation item. It is composed, Your Honors, of senators, for example. The Constitution says only Congress has the power to, the appropriation bill must originate exclusively from the House. The BICAM members, Your Honor, are not Congress. They are congressmen. And more so, the senators. The senators, as I mentioned, has no power to originate an item, but they originated this, Your Honor. They invented these items there, adding about 449 billion in the 281 billion. So if the BCC's acts are ultra vires and no amount of ratification can cure that, it is unconstitutional, Your Honor. The entire insertion of 449 billion, Your Honor, is unconstitutional, especially since, if I may add, Your Honor, the Senate concurred with the House. The House passed 281 billion of unprogrammed. Who is the senator or the congressman in the BCC to propose amendment in violation of the Constitution? So for us, Your Honor, the items may be many, and it could be funded by loans already. It may not even be funded by loans. But if the insertion itself is unconstitutional, then the insertion of this, Your Honor, because it violates the constitutional provision that appropriation bills must originate exclusively from the House, and the Senate may only concur or propose amendments, Your Honors.
In other words, Colmenares, congressional wisdom or the use of this wisdom is not a license to violate the Constitution.
Correct, Your Honors.
My next question. You are of the opinion that PhilHealth funds or any excess thereof cannot be allocated for any purpose other than that identified under the Universal Health Care Act, and to do otherwise would be unlawful. Tama?
That was in the other petitions, Your Honor, we agree with it, although our petition simply said, if Section 1D is unconstitutional because it was inserted by the BICAM, then the circular issued by the DOF is also void because it was based there.
Okay.
And any transfer of funds, therefore, are also void, more so because it took away, it siphoned off billions of pesos from the benefits of PhilHealth members.
Okay, fair enough. Now, if I understand correctly, sir, the General Appropriations Act mandated that excess funds of all GOCCs should be returned to the National Treasury to finance other government programs and projects. However, it appears that we are, this is my observation lang, it seems to me that you are focusing or concentrating exclusively on PhilHealth funds. And no issue is being raised with respect to other government agencies. I would like the petitioners to kindly explain this particular issue. Meaning, if the law Teka muna, nawala na ako. Hold on, for a while. If the law, now under review, would have only required the remittance of excess funds of all other GOCCs, with the exception of PhilHealth, would you still raise the same objections? You may answer later. Medyo mahaba itong tanong ko. This is a series of questions, actually.
Yes, Your Honor.
Because the Equal Protection Clause reminds us that things of the same class should be treated in the same manner. In filing the instant petitions, are you seeking to protect only the excess funds of PhilHealth and not those of the other agencies or GOCCs covered by the law in dispute? What is it with PhilHealth that you should single it out when there are all other agencies which could also have excess funds to remit? Did petitioners even bother to check on the charters of these other agencies if they have similar restrictions as PhilHealth when it comes to excess funds? Or is PhilHealth the only target here, given its alleged enormous excess funds? Why do we have to be selective? Why do we have to leave them behind? What recourse do they have, if any? I think these agencies, in fairness, if they are on the same boat as PhilHealth, they also deserve your help, concern, and protection. Are you not also supposed to take up the cudgels for them? I understand that protection should be extended to PhilHealth funds given the enormity, masyadong malaki, of its supposed excess funds. But what about the other GOCCs whose excess funds is no match to PhilHealth's? Will you not be questioning that also, Attorney Colmenares? If petitioners think that diverting PhilHealth's funds is unlawful, will channeling funds of other GOCCs whose extra funds are not that significant to purposes other than they were initially earmarked be lawful? What will happen, say, for example, the Supreme Court decides this case in your favor, the petition. Now, in the event that you secure a favorable judgment or decision, and the court declares or nullifies the challenge, anong tawag doon? Item 1D, for being violative of the Constitution as maintained by the petitioners. Can the decision of the court in this regard be also applied in the other GOCCs who were not included or impleaded in this petition? Lastly, will all the transfer of funds of these other GOCCs be likewise declared to be unlawful? Okay, it's your turn.
Thank you, Your Honor. Yes, you are right, Your Honor. We should be concerned with all GOCCs. That is why, Your Honor, ang tinamaan dito is PhilHealth and PDIC. We mentioned PDIC, Philippine Deposit Insurance Corporation, 100 billion. 89.9 billion PhilHealth. But we are also concerned with other GOCCs, Your Honors. That's why we challenge Section 1D. Because Section 1D, if we win that case, it pertains to all GOCCs. Because that is where the power to transfer stems. The circular being assailed here from the DOF stemmed from Section 1D. Kaya hindi kami nag-question, Your Honor, ng PhilHealth lang. Kinwestiyon namin ang ugat ng bakit nalipat ang PhilHealth, which is Section 1D. And we believe, as long as Section 1D is there, it may be PhilHealth now, we may win PhilHealth, it could be GSIS or SSS later. Ang mga kasamahan kong kongresista, Your Honor, wag naman yung kalusugan ng miyembro, wag naman yung pensyon ng miyembro. Kaya we are so concerned na baka pati yun ay gagalawin nila, kaya we question Section 1D, Your Honor, which is the root of the transfer of
inunahan
funds.
nyo na.
Yes, Your Honor. Kasi unconstitutional talaga, Your Honor, at baka kung sino pang GOCC ang maisip nila later if Section 1D survives.
Thank you, Congressman Attorney Colmenares. Can I, Madam Clerk of Court, can I request the Secretary of Finance to also take the podium? The current. Senator Recto, I'm sorry, as Secretary Recto. If that's okay, Sarah. Good afternoon, Mr. Secretary. Now, in the interest of full disclosure and transparency, I'd like to inform the parties that Secretary Recto was the former boss of my wife, Marido Rosario, who was a deputy commissioner of the BIR. While her mandatory retirement is due next month pa, she has opted to retire early. She has in fact filed her optional retirement last November. Now, her employment in the BIR would have been a ground for my voluntary inhibition. But since she's no longer with the BIR, I guess there's no need for me to recuse myself from this proceedings, from this case. Okay lang ba? Okay. Secretary Recto, in a press statement dated February 2, 2024, posted on the official website of the Department of Finance, it stated that acting on the GAA mandate, it proceeded to review the excess funds of GOCCs. It was found out that PhilHealth had a substantial sum of excess, unused, and idle funds over the past few years, amounting to how much? 183.1 billion. So it appears that an extensive review of the financial statements of all GOCCs was conducted and revealed that PhilHealth had accumulated a substantial sum of excess, unused, and idle funds over the past few years, amounting to, 181.1 billion. The clear import of the statement is that this amount, 183 billion, I sound like a broken record already, being in excess is no longer relevant insofar as attaining the objectives of PhilHealth are concerned, and thus it could be appropriated to other uses. In the same press statement, Secretary, DOF said that it exercised a, open quotation, prudent and moral decision to limit the return of the excess, idle, and unused government subsidies from 2001 to 2023, thus arriving at 89.9 billion. My question is this, sir. If the entire 181.1 billion is an excess, and apparently, in my understanding, not needed anymore, why should it become an imprudent and immoral decision to seize the entire amount? The point here is that DOF already has found out that the entire amount was excess, idle, and unused government subsidies. Such being the case, how could it be imprudent and immoral to divert the entire amount? If it should be imprudent and immoral to get hold of the entire 183.1 billion, then how could DOF justify describing seizing and divesting the amount of 89.9 billion to be a prudent and moral decision? If it is unlawful to divert the whole of the purported excess funds, or imprudent or immoral, then should it also be unlawful, immoral, and imprudent to get hold of a substantial portion of it? Conversely, if it is justifiable to redivert only a portion of the excess funds, would it not also be legally and morally defensible to take the entire amount? You may respond through your directly or through the Solicitor General if you feel more comfortable doing so. Anyway, the Solgen's job is supposed to take up the charges for the OF. Up to you. It's your call, sir.
Thank you very much, Associate Justice Rosario. If I may, if it may please the court, before I answer the question, may this representation be allowed to make a brief opening statement to provide context insofar as these issues are concerned?
How long will it, if you don't mind me asking, how long will it take you to conclude your brief statement?
Very brief.
Okay.
So thank you very much, Associate Justice. Honorable Justice, Honorable Chief Justice, and Associate Justices of the Supreme Court, good afternoon. Thank you for granting us the opportunity to present our side today. To begin with, I think it will be wise to explain the context within which this policy move is being undertaken. The bigger picture as to why we did what we did, so to speak. First, we are still recovering from the pandemic that gave us the hardest economic blow, a contraction of 9.5% in 2020, the lowest since post-World War II. To address both health and economic needs, during that crisis, the government had to borrow more money, utang na minana ng kasalukuyang administrasyon. By 2022, when President Marcos Jr. took office, our national debt soared by 6.8 trillion pesos. This surpasses the combined debt of all previous administrations, bringing our debt to GDP ratio from its lowest level of 39.6% in 2019 to a high of 60.9% in 2022. And now it is our responsibility to repay these large borrowings. We inherited this debt, but we do not intend to simply pass this burden onto the next administration. We intend to try our best to reduce it. Against this backdrop, geopolitical tensions, two hot wars, a trade war, and the looming Cold War, as well as supply chain disruptions from the pandemic, interrupt our recovery efforts. Around the world, inflation has surged and central banks raised interest rates. Thus, Congress mandated in the 2024 General Appropriations Act to sweep the unused, idle, and excess funds of government-owned and controlled corporations to raise more resources to support the President's priority programs to enhance economic recovery efforts. As the Solicitor General has accurately pointed out early in this oral argument, this move is a temporary and common sense approach within which legal bounds to fund critical government programs for Filipinos. And I implore you, Your Honors, to consider our job at the Department of Finance. We are the government's chief fundraiser. We are called to steward the nation's fiscal stability. It is our duty to put every peso to work for the people. Hindi po pwede na kapag may nakitang malaking pondo na natutulog at hindi nagagamit para sa kapakanan ng taong bayan, hahayaan na lang. Sleeping funds serve no one. Every idle peso is a disservice to every Filipino. To put into perspective, based on the 2024 GAA, we had an appropriations of 5,768 billion pesos, of which only 4,273 billion pesos were supportable by revenues. Thus, reckoned on a daily basis last year, our expenditures amount to 15.8 billion pesos a day in cash, of which 11.71 billion pesos in cash were funded by revenue collections, and the rest, 4.1 billion pesos in cash by loans. Every 24 hours, kada 24 na oras. This is the daily math of governance. So at dusk, when the sun sets over Manila Bay, a spectacle I see from my office, I would often ask myself, nakakolekta ba tayo ngayon ng 11.71 billion pesos sa araw na ito? The national budget is a catalog of expenditures. Every item therein has a price tag, paid in taxes, non-tax revenue, or by debt. Our role in the DOF is to pick the tab of what the budget has ordered. Kung kulang, we pay in credit. And we are wary not to max out the National Philippine Credit Card. Thus, this move to sweep the unused excess idle funds of GOCCs is in line with the principles of our medium-term fiscal framework to ensure the country's macro-fiscal stability. And that is to consolidate all public resources so that these are mobilized and utilized to gain the maximum benefit and high multiplier effects for the economy and the Filipino people. This framework ensures that we reduce our fiscal deficit from a high of 8.6% of GDP in 2021 to only 3.7% in 2028. Last year, we already hit our target of reducing this to 5.7%. This will allow us to sustainably reduce our national government debt to 56.3% in 2028. And just as what we did during the pandemic through Bayanihan 1 and 2, we see this as a Bayanihan 3. A Bayanihan 3 not funded by new taxes, but one funded by the funds already in our possession.
Senator, are you about to wind up?
Just a few more minutes, then I will happily answer all your questions. Just to
Hindi
provide
nilagay pala yan,
context.
di po nasasagot yung tanong ko.
I'm sorry?
It's okay.
Yes, thank
Please proceed.
Thank you. But one funded by the funds already in our possession. A Bayanihan 3 that mobilizes all our available resources, all idle, excess, and civic public funds to help the economy recover faster, create more jobs, increase incomes, and reduce poverty in the process. We wouldn't be doing our job, Your Honors, if we willfully neglect our duty to exercise fiscal prudence in this matter just because it is unusual. We wouldn't be doing our job if we clung to convention over common sense. And now let me respond to some points brought up during the previous sessions. First, why PhilHealth? Alinsunod po sa batas. Hindi lamang po ang PhilHealth ang nag-iisang GOCC na aming inutusang magbalik ng sobrang pondo ayon sa 2024 GAA. Tinignan po ng DOF ang lahat ng mga natutulog na pera ng lahat ng GOCCs. And with our extensive review, we found out that PhilHealth has accumulated a very substantial excess, unused, and idle funds over the past few years. This is not beneficial for one reason. Every peso unused is a benefit denied to a Filipino citizen. After carefully and cautiously computing the reserve funds of PhilHealth, its excess, unused, and idle money actually amounted to a staggering 183.1 billion pesos.
Senator,
yes, sir.
I'll just respectfully reiterate my question.
Yes.
And please answer as briefly as possible,
Yes,
given the limited time that we have.
yes. If your question
So
is,
it is your position, sir, that if the funds is considered by your office as excess, idle, and unused, meaning no longer relevant insofar as attaining the objectives of that GOCC, whether PhilHealth or whatever, it could be appropriated to other uses.
yes, based on the mandate given to us by Congress as found in the General Appropriations Act, particularly 1D.
Congressman Attorney Neri,
Yes,
do you agree?
Yes. I really commiserate with our former colleague in Congress because he's a tough position. Of the executive to gather all these unused funds, of course, is important. It's fiscal responsibility to gather unused funds. But fiscal responsibility, Your Honors, please, ends when it transgresses the Constitution. Ito ang question namin, Your Honor. Kung importante sa executive palang kunin ang pera ng GOCC, why did not President Marcos put Section 1D in the NEP? Kasi he was expecting 281 billion. Why did the House and the Senate did not put in Section 1D? Because it's only 281 billion. It was the BICAM, in all its wisdom, who increased it to 749 billion, at ngayon nag-isip sila, ay, paano natin ponduhan ito? Aha, GOCC, in-include nila yon. So that does not justify, Your Honor. If the executive thinks we need to mop up liquid unused funds, yeah, but put it in a proper way, Your Honors, please. Put it in the NEP and have it approved by both houses of Congress rather than surreptitiously insert it through a BICAM committee, Your
You have
Honors.
already made your point, Congressman. This is, again, for question is addressed to a good Secretary of Finance. And is related somehow to the previous question. It was argued, meaning the group of petitioners, that there was invalid delegation of authority as the power to transfer appropriations is vested only among the select government officials, which includes, the President, but not the Secretary of the DOF. As allegedly what happened in this case, in the implementation of DOF Circular 003, 2024. Now, Mr. Secretary, how will you reconcile this argument with the doctrine of qualified political agency, which postulates that the heads of the various executive departments, including the DOF Secretary, are the alter egos of the President, and thus the actions taken by such heads in the performance of their official duties are deemed the acts of the President unless the President himself should disapprove such acts?
With all due respect, Associate Justice. I will leave the legal arguments to our Solicitor General, and I will confine my responses to the policy at hand.
May I request Sergeant Guevara to please take the mic? The mic. Please use the mic.
Good afternoon, Your Honor. Your Honor, that constitutional provision is not at all applicable because that provision speaks of savings. And savings, as defined in NAGAA and as ruled by this honorable court, pertains to that portion or that balance of an appropriated amount that is no longer needed for certain reasons, like the project for which that fund has been allocated has already been completed, or that project or program has been finally abandoned, or for the reason that due to some efficiency measures taken by that government agency, then certain amounts were saved. So it is that concept of savings, Your Honor, that is referred to under Section 29(3) of Article 6 of the Constitution, for which only the President, the Chief Justice of the Supreme Court, the heads of the constitutional commissions, the Senate President, and the Speaker of the House are authorized to transfer or to effect, to augment another item in their respective appropriations. So that is not the one that is the subject of Section 1D of the GAA 2024.
Congressman, okay, you're already excused. I have one last question for Secretary Recto. Short lang po. Which other GOCC or GOCCs, meaning other than PhilHealth, have remitted their fund balances to the National Treasury pursuant to item 1D of the 2024 GAA? And how much was each remittance? Were those remittances already spent? If so, for what purpose? My second last question. If the court were to direct the government to return to PhilHealth and the other GOCCs their respective remittances, can the government comply with such directive? What impact will such ruling have on the financial position of the government? Kindly elaborate.
Yes, thank you very much, Associate Justice. There is another GOCC that did remit to the National Treasury, and this is the PDIC, roughly about 104 billion. We could submit to the court the list of projects that that remittance was funded, including the Salary Standardization Law 6 for government employees. Now, having said that, Mr. Bray, I think your last question was, will the government comply with a ruling of the Supreme Court?
Yes, and what will be what will happen to the government?
Yes.
After that?
Naturally, if the government were to tell the executive to return the money, we will include that in the National Expenditure Program for 2026. But having said that, assuming if the ruling were for 2025, that will add a fiscal pressure to our deficit. And that would entail us not hitting our deficit targets this year. And if we miss that, then we may not attain our coveted credit rating upgrade that we foresee in the next 18 months.
Thank you, Secretary.
Yes, thank you.
Can I, Madam Clerk of Court, can I also call to the podium the members of the panel of experts, amicus curiae? I'm sorry. Secretary, former Secretary Margarito Tebes, please. For the benefit of the audience, especially the non-lawyers who have been closely monitoring the proceedings in these cases, amicus or amici curiae is a legal term which means friend of the court. As you may have observed, the members of the panel, they all look friendly and sociable, amiable as well, just like Justice Amy. Now, this friend is a person or organization that is not a party to the case, but permitted to assist the court by offering their expertise or insight that has a bearing on the issues in this case. So we will now try to seek their assistance and expertise to guide us in the handling of these cases. Secretary Tebes, good afternoon, sir.
Good afternoon, Your Honor. And the others.
I was very reluctant to include you guys in my interpellation because I really find it difficult to pronounce your designation as friend of the court. Did I pronounce it correctly? Amichi Curie. Okay na, no? Pwede na, no? Curie. You have characterized as a prudent fiscal strategy the utilization towards productive programs of idle public resources. You have likewise noted and enumerated the acts of previous administrations, if you remember, specifically those of former Presidents Ramos, Arroyo, and Duterte, of authorizing the transfer of idle resources to support the country's fiscal needs. It would thus appear that there is a consistent practice of previous administrations of reallocating public funds considered as idle to support other government programs. Based on available data, and in your informed opinion, Secretary, have these past allocations of idle funds historically made a significant and positive public impact on government projects? In other words, have these reallocations proven to be prudent fiscal strategies?
Can I answer now, Your Honor?
Yes, anyway, but I may just explain. I answered the question to gather information on the historical effectiveness of the previous reallocations made by the government of idle public funds. A practice which appears to continue and apply to the present situation of reallocation of PhilHealth funds. Go ahead, sir.
Yes, Your Honor. These situations took place under very difficult circumstances. In the case of President Ramos, it was done during the time when the Philippines and Asia were actually confronted with the Asian financial crisis. So that in the case of President Ramos, I recall he said that let's try to get all the balances from different institutions that are now in the different banks and utilize this to address the crisis. And that was helpful during his time because I recall that after such decision, the government or the administration of Ramos was able to address the fiscal problem. In fact, they were able to register a surplus for a year. In the case of President Gloria Macapagal Arroyo, it's a similar situation because as most of us who have observed the operations of special funds, the special funds tend to have a tendency to increase. And therefore, in terms of what the Secretary of Finance said, there probably should be a way of making use of these funds if they're not utilized. No? So that particular executive order, I understand, has not yet been abolished, and I think that could still be implemented, but again, in very rare circumstances. In the case of President Duterte, as again the Secretary of Finance indicated, again, this similar situation, balances from different government agencies would have to be reallocated as needed in response to COVID-19. So these circumstances, in fact, were already there But of course, even in the case of the 2024, again, the effects of the COVID have actually been actually permeated all the way to 2024. There were, of course, other considerations, but there was a fact here that indeed the amount of the unprogrammed appropriations increased from about 280 to about 700. Historically, Your Honor, the average is about only 5% of the General Appropriations Act. 2024 was about 13%. No, a prudent number, more or less, would be about 5%. No. So, as to your question, yes, there were similar instances. Thank you.
Thank you, Secretary, for sharing your thoughts on these issues. Now it will be the turn of Dr. Beverly Ho, Lorraine C. Ho. So,
Dr. Beverly Ho is not around.
sorry. Anyway, that's supposed to be my last question. The other who are the other members of the panel?
We have Dr. Solon and Ms. Zara, Mr. Africa.
Okay, anyway, I'll just forego this last question. I'm done. Thank you very much, Chief.
Considering that it's already past 5 o'clock, and it's a long day for the court because we had an en banc session this morning. Today's oral arguments is hereby adjourned to resume tomorrow at 10 o'clock in the morning. May we request the Solicitor General to submit to us the message or the statements of Secretary Recto earlier, which was not completed, so that every one of us can read that. Please make it a part of your submission. Thank you. And also, we also request that all those present today to come back tomorrow for oral arguments because some other members may still ask questions for the Secretary and other people present today. Okay? So thank you very much. We'll adjourn today and resume tomorrow at 10 o'clock in the morning, whole day. Hopefully we can finish the oral arguments tomorrow. There are just a few remaining justices who wants to ask questions. Thank you. Attorney Maripe?
There are no other matters, Your Honor.
Session is adjourned. I'll go ahead.